I wonder why they don't got no sound. Okay. I wonder why they ain't got no sound. So while we wait for the figure out what's going on, get the likes up, gang. Get the likes up so everybody knows that the live is on. And that the court case has finally started. The judge and came out the bathroom finally, whatever using they're doing. But if everybody could get that, hit that like button, share the room. Maybe we can't get some captions put on in the room. I'm not sure, but let's go, gang. Let's get the likes up and let's see how this goes. Hopefully, is it closed caption? I'm not sure if you can even get it that way. Um, they just need to turn the damn sound on. Is what they need to do. Um, Anybody, if y'all want to come up and chat, come and get up on the panel with me so we can see what we got going on, so we can, get some narration going since they not gonna give us no sound. Um, hit the link and come up so we can give it. I guess put our own words to the live while we wait for paperwork and everything to come up. Everybody, hit the like button, share the live. I don't know. If y'all see the StreamYard link in the chat, but it's there, just hit the link and come up. Whose lawyer whose lawyer is that? Because I ain't been following this case so well. Is that Young Thug lawyer or is that the state's? Let's see. Too much. They got too much. You say too much confidential information. It's probably why they don't have that sound. Man, what kind of confidential information? They have sound on all kind of serious murder trials. So they gonna protect this live. I mean, protect this court. I guess. Yo, what's up?
Hi, how are you?
Good. How you doing?
I'm doing wonderful. I am a 56-year-old grandma. I live downtown Atlanta. So I've been very interested in this case. And from a different generation, so my perspective may be different.
That's perfect though. We need everybody's, different perspective. So your perspective would be great to hear just as well as the same generation.
Okay. My perspective on Ghana. Um, from my understanding and growing up, men who don't want to do extended time in prison, especially this younger generation, but even the older, some men have always been, you know, telling something in order to lower their prison time or not going at all.
Hmm.
Would you agree with that?
I definitely agree.
Okay. So I just hope this is a teaching moment for the younger generation to stop applying that snitching label as if it's something negative. Men have been doing this for decades.
Yeah, and
For
maybe don't
decades.
call it snitching, call it telling. If you're not a part of it, you didn't snitch. You just telling your part. You telling
Yeah.
your truth. So
Hmm.
you right.
And Ghana, his role in the RICO was very minute, but RICO, the charge, is organized crime. you'll get the same time. So he had to give it up, in my
True.
opinion.
You're right, because I'm not completely familiar with the RICO Act, but
Hmm.
you'd have to set yourself apart and show that you wasn't a part of that gang activity. So I'm with you on that one
Right,
too.
right. What RICO is and does is organized crime charge. And before they bring a RICO, it's a very solid case, very solid. And they treat the boss and every member, all the 28 members, equal under RICO as time, that can be spent in prison. And
Oh,
so
okay.
if yes, it's a everybody go. And most men who haven't
What?
dared by
Boy, y'all ain't talking about
huh? Well, who is that?
Don't worry about it. They gone.
Okay. Yes, because this is very important. And so a crime by association, if I didn't do it, I'm just saying I'm not going to prison for no 25 and 30 years for nobody.
Who you telling? And that's what I was just telling the gang about. We were talking about in the clubhouse how see murder knew who did whatever, but on
Mhm.
that snitching and no telling and all that mess, he wouldn't speak. And then the guy who did it didn't even speak up. So you better tell what you know if you know what's good for you.
And you better tell what you know before someone else. Because there is no other plea deal for anybody else of the 20 something folks. They got what they need now. You got the co founder of YSL who's already, have pleaded and say he co-founded this organization, and you have Ghana. Any of those other 24 people, they missed the train. They missed the train.
Miss Breezy, that was not paperwork, so I don't know who you talking about cut off who, but that was somebody else that came up on the platform, ma'am. But
Hmm.
you better get the best deal. You right, because once they get all they know what they need you for.
And so some people say, "Oh well, Ghana just had to wait a little bit more, and he wasn't going to get." They don't really understand RICO. Separate from drug charges, gun charges, even murder, RICO stands alone on its own charge. And it's a very serious crime if you're charged under. Not even many gang members or these low level street guys are being charged with RICO because it was originally created for the mobsters back in New York. And so when it's an organization, and that's what they're calling this, and that's why gangs, they operate as a business organization.
Right. Come on, y'all. Get the lights up. Don't forget to share the live. Get the lights up. I'm sorry. Go ahead.
No, that's okay. And I would like to hear from you a little bit. What are your thoughts?
Um, I always talk, so it's always good to
That's
hear.
why I came to join
I
you because I know
appreciate it.
the channel owner. He said he had something to do, and then you was up here, and it makes it very interesting. So to listen to others and hear others.
Yes, ma'am. So hit the link if there's anybody else that would like to come up. That's what I said. I can't believe it ain't no sound, but I guess I can.
I
But
know I'm very upset about that too.
I would have definitely liked to at least hear, something. They didn't have to make it completely quiet. So, um, I don't know. But I think with the organized crime, like you said, the only difference is in music. So when it's tied to music, a lot of times they have given them the blueprint to everything. Like back in the days, the mob bosses, they didn't put all that in any type of music or
Exactly.
any type of mainstream promotion. Now
Right.
they're putting it all in their music and in their videos, and like we said earlier, they giving them everything they need to know in order for them to use that. They're giving them what they need to arrest them, and that's so crazy. You're telling on yourself.
Right. Yes, and I agree with that because social media putting your crimes in lyrics. Now that's one thing the men of old did not do. And that's a part. I was speaking to a friend this morning. It has to be either a God complex or mental illness. Otherwise, why would a millionaire do this? Say, eh, place himself into the risk of prison. And like I said, I'm going to just give you a little bit of Atlanta because I am downtown Atlanta. I'm in a middle class neighborhood where maybe doctors, lawyers, and business people, veterans live. But it's only one block from where Rayshard Brooks was killed. So with every community, right outside them gates, there's life. What is upsetting to me is the gas station that I go to is in the heart of it all. So like I say outside, I mean, it's just one block away. I'm down to pumping gas to maybe $10 because I don't want to stand there and fill up my car. I could be shot in the crossfire. And this was an election year. And I don't know if you all heard about that lady that just got killed in Buckhead. Are you familiar with Buckhead, Georgia?
I've heard not like that.
Mhm.
I don't know enough about it.
Well, it's a very prestigious area where the athletes and movie stars and the cream dollar cream of Georgia lives. It's also where Lil Durk lives and others. And the crime that has exploded in this very prestigious area, it is bad to the point where Buckhead wanted to separate from Atlanta, Fulton County, because it falls under the jurisdiction of Fulton County, paying good high taxes.
Uh-oh, we didn't went off
What's
the air.
important is that
Uh-oh,
Oh,
and we
it's
it's a
back
on.
it's a
now.
pretrial statute. That's not
Hey.
to be confused with 17-5-54, which is the return of property after a trial. So the reason that the 17-530 statute is particularly important is that, and I'll read it for you all. I know you all probably know this, but just so it's in the record. A defendant aggrieved by unlawful search and seizure may move the court for the return of property in the possession of which is not otherwise unlawful. So that means, of course, if it's contraband, other drugs, weapons, or other things that wouldn't ordinarily be subject to being returned, and to suppress as evidence anything obtained on the grounds that the search and seizure without a warrant was illegal, or the search and seizure with a warrant was illegal because the warrant is insufficient on its face, there wasn't probable cause for the issuance of the warrant, or the warrant was illegally executed. The motion shall be in writing, which that one was, state facts showing the search and seizure were unlawful, which it was. The judge shall receive evidence outside the presence of the jury on any issue of fact necessary to determine the motion, and the burden of proving that the search and seizure were unlawful shall be on the state. If the motion is granted, the property shall be restored unless otherwise subject to lawful detention. Lawful detention would be contraband, of course, and it shall not be admissible, mandatory, shall not be admissible in evidence against the movement in any trial. The motion shall be made only before a court with jurisdiction to try the offense If a criminal accusation is filed or an indictment or special presentment is returned by a grand jury, the motion shall be made only before the court which the accusation, indictment, or special presentment is filed and pending. The last time that we were in court, the court, Mr. Steele, I think we admitted for the court's consideration D1 through 10. Within those documents was the order Judge Newkirk entered. Can I have those, Christine? Do you have those? Do you have those ones? Are they up here? Okay, hold on a second. Okay.
This been going on for a minute.
No, thank you. All right. All right. D1 was the accusation that was filed in this case, and that was related to the possession of marijuana charge. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was the supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number 16 SC1, and there are 6 4s. Specifically, that just over an ounce of marijuana, it is hereby suppressed and cannot be used in evidence by the prosecution in the trial of Jeffrey Williams, signed by Henry Newkirk on the 10th of April, 2017. There was a motion for reconsideration that was filed or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April 2017. The order, it reads as follows. The court, having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April 2017. There is a exhibit from our last hearing on the 17th, D9, which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. Read the State of Georgia versus Jeffrey Williams, accusation 16 SC1 44444. Dear Mr. Bailey, I hope that all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffrey Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case was null pros and prosecution is ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The City of Atlanta is not releasing the same, as they still have the same marked as evidence, according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the 2 Williams, one being the defendant, one being the senior, his father. D10 is the warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November. So the court's concern is that while you all, the state that is, think that Judge Newkirk just specifically excluded marijuana, he did, but the legal premise behind it would be fruit of the poisonous tree. Anything that was taken in that house at that point in time would be subject to being suppressed. And that's the first thing I'm going to let you all address. The second thing that would be of note is that under 17-5-30, this property was requested to be returned. And the statute's pretty clear, shall not be used in a future criminal prosecution. That is different than the return of property statute during trial 17-5-54. So, yeah, that's why I preface this. I've had an opportunity to take a look at Judge Newkirk's transcript, which will also be included for purpose of the record, is the next court exhibit from the 3rd of April of 2017. So with that, Ms. Love, what say you and your colleagues?
Yes, Your Honor. First of all, Your Honor, understanding the court's review of the transcript, I want to point out that in ruling on evidence that pertained to the possession of marijuana charge that Mr. Williams faced in that indictment, the court specifically, during the course of the proceedings, clarified during an exchange with the prosecutor, he is only seeking to suppress the marijuana.
I agree with you that, but the legal premise would still hold on anything that was taken in that home by a search warrant. You had an arrest warrant issue, and then you had a search warrant issue. So if Mr. Steele challenged the arrest to begin with, the warrant or copies of the arrest warrant and the warrant under Baez, versus the state, which is a 206 Georgia 552, which he cited at that point in time. That would make it so that anything else in the house that was taken would have been subject to being suppressed. Mr. Steele amended his motion. He asked for everything.
My bad gang got booted out. We back on silent mode again. They must be giving some very important information or something.
Yes, it's about the a search warrant from a previous case, and they're saying the warrant was illegal for that case, but they used some evidence from the house in this arrest, the Rico arrest, and so Thugger's lawyer is hoping to get rid of what they call the tree of poison fruit. It's like you can't use any illegal evidence to arrest, detain, or try a defendant. Fruit of the poison tree. That's what it is. So if the fruit is poison, the tree is poison. The evidence.
I'm with you on that one. That you can't bear any good fruit if you're a poison tree. I got you.
Um, my question, and I've had a friend that made the statement: were these gang? Was Thugger a gang member
Hey,
before he
hey,
was a
Queen,
rapper?
hey, Queen Regina. Can you cut your camera on for me real quick?
I'm not dressed up. Can I
You
do
don't gotta
it?
be dressed up, girl.
Okay,
Yeah,
okay.
it's okay.
Just one moment.
All right. You ain't gotta be all dressed up. I don't even be dressed up. There you go. See that?
Yeah.
How you doing? Yes, love. That's good.
Okay.
That was just the first time I had never talked to you before, so we got to be
Mm.
careful
Oh, I
and make sure
understand.
we
I'm
meet
not dressed up.
everybody. Oh,
Oh
it's
no,
all
I'm a
right.
criminal justice major. I wouldn't even be up here if I didn't have anything to add.
I know that's right. But go
Yeah.
ahead, girl. Mm.
So, the question is for some of these rappers who are doing these lyrics, which is evidence, were they gang members before they were rappers, or are they rappers that became gang members?
You know what? I think it's a little bit of both. I ain't
Mhm.
gonna lie to you. A lot of times they're in the streets and it's
Half
not
and
even
half.
necessarily gang is they see it more as like a family type thing or boys hanging together and then they come up with like a title, you know what I'm saying, for their group and then it turns into a gang, I think. But I don't think necessarily is I don't know, I guess both at the same time as I don't know if they set out thinking that it's more like gang activity, anyway.
Thank you.
Well, if they set out
Oh,
thinking
you hit
that
it right in
it's
the
more
head.
like gang activity, anyway. Somebody has some hella playback going on. Um, but hold on one second. I was reading something. Anybody else got something want to say? Who else is up here with me? On the end. Who's that all the way to the right? Let's see here. Um, Let me see. Oh, that's Black Thunder, girl. How you doing? Let me see, y'all.
Black Thunder.
Girl.
I'm great.
What would you like to add to the conversation?
I just really wish we could have heard what was going on because I seem like we missed out on a lot.
Who did Young Thug's hair? How he got fresh, twisted dreads and braided to the back, and how is his hair so nice? They do hair in jail? I mean, they got like special. I mean, I know they do. Men do hair in jail. Well, he probably wouldn't have no problem sitting between another man's legs. So
Oh, y'all doing too much. Jill, don't even be like that, man. Sit in a chair like a normal person and get your hair done.
Oh, they definitely do here in jail.
Oh my goodness.
Better than women.
Oh Lord, look at him because he is done to the T. They got him twisted and then to the back and all of that. Mm-mm.
He probably did his own shit.
No,
Answer your
cut it out.
questions.
Hey, if he wearing dresses
Boosie.
and shit, who knows?
Listen, he ain't did that on his own. Like,
He probably
Wow.
designed dresses and all that shit. But I know one thing for sure, Gunna a rat. He ate the cheese.
In female prisons, they do have licensed beauticians.
Okay, all right, Mr. Steele, sorry about that.
They're all on their back.
Okay, so I do have the transcript from April the 3rd of 2017 with, and I've labeled it as the court's next exhibit in order. Court's 2 for purposes of this motion.
So, Your Honor, if I may go backwards for a second, if that's okay, I'd like to just first discuss and take care of State versus Alford. It's ALFORD, and it's 347 Georgia Appeal 208. It's a 2018 case that the Honorable Prosecutor has cited to this court. It's in Division 3 that the prosecution is relying upon, and it is wholly inapposite to what we're dealing with here. What we're dealing with here in Court's Exhibit number 2, which is the transcript from April 3, 2017, has nothing to do with what happened in Alford. In Alford, Mr. Alford is a passenger in a vehicle. The car gets stopped. Law enforcement officers see open containers and they smell marijuana as they approach the car. The officers then ask Mr. Alford, is that your backpack at your feet? And the answer is yes, and there's contraband, there's drugs inside the backpack. Mr. Alford is arrested and he's prosecuted for that. The Honorable Trial Court had a pretrial motion to suppress, and the state of Georgia was on notice that Mr. Alford, just like the Honorable Mr. Williams, challenged the actual arrest. And the state of Georgia did not bring in a certified copy of a county ordinance saying that you can't have a person can't have an open container in a car. Because of that, the trial court granted the motion to suppress. The state of Georgia appealed. What happened in the Court of Appeals was as follows. The Court of Appeals said that's exactly right. Without introducing the certified copy of the county ordinance, there was no arrest for that purpose. But what the court then went on to hold is, however, when law enforcement officers lawfully walked up to the car, they smelled marijuana. And the odor of marijuana in the state of Georgia is a reason, probable cause, to search the car under the automobile exception. And because the automobile exception kicked in, it didn't matter that there was no certified copy of the county ordinance, and the Honorable Court of Appeals of Georgia found that the odor of marijuana was sufficient probable cause. The police then could search the car under the automobile exception. The backpack then, therefore, should be searched. The contraband inside the backpack should not. In Court's Exhibit number 2, so Alford is like a waste, respectful, I don't mean to be rude. It is just not even close to what we have here.
Can I hijack for just a second, Mr. Steele?
Of course.
We're going backwards. We should be going forwards. That, I agree with you with your, at the status of your hearing in front of Judge Newkirk, the issues involving the search warrant, the arrest warrant, the search warrant, and these issues would have been, it's a snapshot in time. Since you filed another motion to suppress, the state now is willing to at least present forth evidence to show that that the arrest warrant, the search warrant, and the seizure of these particular items, that there is a basis, because we've gone forward and it's another case. So, can you address that for me? Because I don't believe that I have to kind of look at it from my foxhole, because this evidence is related to, you filed a motion to suppress in this case. So I can't rely totally upon what Judge Newkirk has indicated. And also, this case was never appealed, so there's no really appellate ruling on this issue. So I would argue it's ripe to consider again.
I would respectfully disagree. I wish I could do that in every case that I don't win, that I can come in and do a second bite at the apple. This is the exact
But it's a
issue.
different case.
No, so then the state can just, I win a motion to suppress?
No, it's a different case. Okay, it's a different case. That was just a possession of marijuana case. This is a RICO case, and they're arguing at this point in time, since you filed another motion to suppress, that we look at probable cause and the other things from the vantage point of 2022.
Your Honor, I filed a motion to suppress based upon the law of the case. It's a final order. It was not appealed by the state of Georgia. It is a final order. It doesn't matter. It didn't go up to the appellate court. And it is the same issue that's already been litigated between the same parties, Mr. Williams and the state of Georgia. They're still the state of Georgia. It is res judicata, and it is collateral estoppel, and all that is in my motion to suppress. Also, it is not accurate to say that Judge Newkirk did not consider fruit of the poisonous tree. Judge Newkirk considered the following. My motions, which are in front of the court, the original motion and the supplemental motion, challenges everything that was taken from Mr. Williams' home.
Your motion to suppress is D2, and your supplemental motion is D3.
And it challenges everything that was done because the police unlawfully, as found by the Honorable Judge Newkirk, entered Mr. Williams' home. So what happens at our hearing, specifically at transcript page 18, this is on my cross-examination of the lead officer.
I'm with you.
Specifically, starting at line 5, or line 3. The answer is, yes, sir, I do believe there was an arrest warrant. I interrupted. I didn't mean to interrupt, but I interrupted. I said, I didn't mean to cut you off. The answer continues. That is what the warrant was for. Yes, sir. Then my question is, and that warrant was from a long time before. If you know, and if you don't know, we can get the information through someone else. Answer, I don't know the exact actual. I then asked, were you aware the warrant or the case was eventually dismissed? Answer, I'm not certain, sir. My question, so law enforcement officers do not have a search warrant, though at that time, this is simply an arrest warrant. Answer, correct. On page 33, which is what the state is trying to hijack, to use your word, Your Honor, this motion's transcript and wrongly mislead the parties on what it says. The trial court, Honorable Judge Newkirk, on line 14 states, all right, no other evidence, brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that, in the motion filed by the defense, that law enforcement officers did not have the right to enter the home, did not have the right to enter the home to effect the warrant. Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page
Can I interrupt you a second?
Of course.
IT's about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entry in Mr. Williams' home. Then there are two parts here, and that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause? Then skipping, Your Honor, to line 21, same page 34, this is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve-out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in the home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said, at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to effect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appealed. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's not the way. I don't get to do that, ever.
But it wasn't appealed. I mean, there wasn't, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, I know you wouldn't appeal it, but.
And the state doesn't appeal. What does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties, on the same exact issue. They don't get the second, in the case law, it says second bite at the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs, that is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me the opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville, any and all evidence located and I stress this, Your Honor, all evidence must be suppressed. It is not the way you're being told by the Honorable District Attorney's Office. This was not about, oh, the judge only suppressed marijuana. That is just patently a intellectually incorrect way to interpret this. On page 39 of that same transcript, line 25, I continue. First, 1, there is no certified copy or any copy of an arrest warrant in DeKalb County under Baez, which the court already spelled B-A-E-Z versus state. And then we get into that arrest warrant. And then I say on page 40, Your Honor, line 10 in the middle, is that if there is no arrest warrant, the police entry into, and I said, appellant's home was unlawful, and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1. Mr. Williams demanded in paragraph 7 of the supplemental motion and challenge that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is G-A-I-T-H-E-R, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said right, period. So my issue before this honorable court is the first entry obviously without the arrest warrant at this hearing is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing. Same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting on line 4, I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about. And I challenge that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there, and so they could go into the house and get him? That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion which the court filed does not have. What The prosecutor says, and that is the copy, the supplemental one. Again, he's not challenging the arrest in this case. He mentions something in there about the DeKalb arrest warrant. If he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of court's number 2, the district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line 51?
51, okay.
Yes, sir.
All right. Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone or standing on its own. And I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home. And thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case. And I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant? We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now, you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court. And that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant. So that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows. All right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything, so that might have been harmless, excuse me. That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this honorable court with as much earnest and power and professionalism as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home. He is the victim of constitutional rights that have been violated, and the state doesn't get to go back and do it again. Then Judge Newkirk's order, if you look at his order carefully, Your Honor, he does not just suppress marijuana. The prosecution, and they're great people, but on page 33 is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now today the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just show you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
And Your Honor, in the...
That's the first one.
Thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April, 2017.
Filed in on the 11th of April,
Right.
2017.
So D4, order granting supplemental motion to suppress, and I'm stressing it, any and all evidence located from defendant, excuse me. It's Mr. Williams' home. It says, it's used defendant's home. After hearing testimony, a stipulation of testimony, an argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clearer in the world of what was suppressed. The prosecution is intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation, that's all, the accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the honorable court. This is just not the way I'd write an order. But you know where the court did get the language of what the state wants to rely on, specifically just over an ounce of marijuana? It's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed and it's in your court's file. I believe it's defendant's number 10. I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding it, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017, the state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite, and Cellbrite now has better. Open the items. They don't get another search warrant. The legislature then says that the last 3 lines of this code section, Your Honor, any search warrant not executed within 10 days from the time of issuance shall be void.
Mr. Steele, sorry. Mr. Steele, go ahead, sir. Okay, go ahead, sir.
(17-5-25), the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his stolen, the property that they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal and say break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that that case matters to this. That they had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question. And I think, I'll answer any other questions, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Your Honor, I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, it's styled and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean.
So, Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law, and I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
did, though. That's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or at a minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that the cell phones are fruit of a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day, and I think that's really clear from the court's language in the transcript. Specifically in the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is at page 55 through 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant, we can do that today. We have the witnesses here. If this court can make a ruling whether that search warrant was proper. And we have testimony. We will explain the delay. We will explain that there was not the appropriate software available at the time of the warrant. We'll explain why all of that was lawful. But there's been no time to litigate that. The question now is whether there was a previous ruling on the fruits of the poisonous tree, and Your Honor, there just wasn't. And Your Honor, we have here the law enforcement, I do mention this briefly in my case, there was no finding that his rights were violated. There was a finding that the state did not meet its burden. Here, the officers acted in good faith. Again, we are prepared to show that there were proper warrants for everything. We haven't had that opportunity yet to show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree, and if the court were to find
You took more than the marijuana. Cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, is not otherwise illegal, is returned. 17.530 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm gonna take 5 minutes, okay?
Thank you, Your Honor.
Okay, all right. We're gonna be in recess for about 5 minutes. Okay.
Order the court, guys. Thank you.
Gang, gang. What's up with it, gang? Check out the game, man. Hey, my bad, dog. I had the volume down. You know what I'm saying? I had the volume down. You know what I'm saying? That other one. But I just got in here. We had our engineers running. You know what I'm saying? Got the engineers running. Getting down there. Shout out to the gang. Shout out to everybody on the right down there. Y'all know what's going on, man. Y'all see it. Y'all see it. Well, let me do it real quick. What do y'all think about what y'all see what's going on? What do y'all think about real quick? Cause what do y'all think about what's going on? We got Kimberly Whalen. And who is this queen real quick? Who is you, queen? The crowd been saying some stuff. What do you know who you is real quick?
I am Queen Regina. I'm a criminal justice major, a registered nurse, and a U.S. Army veteran.
Who you been getting into? You been getting into with people? People in the crowd say you getting into with people, and
I am a 56-year-old young man. I don't participate in whatever you all call as beef. And there's a backstory to my being attacked by a group of young men. And they met the queen. That's all I can say.
Well, tell me about it. We got a little time. We on a break.
Well, I was a moderator for a 400,000 subscriber count. Okay. And there was this other content creator that had linked up with the content creator and started calling himself the cousin of that content creator. So he was a cousin by day, and I moderated by day. But this other content creator started verbally attacking me. His cousin's, and I'm going to put that in quotes, moderator, very viciously gave out my telephone number and address. And so, I'm 56. I don't know what this is. I'm a moderator. But I do know it's not appropriate giving out my private information.
All right, well, do me a favor, because we think cut your camera back on. Let me talk to you real quick. I want to see your face when I talk to you. Let me see. Okay, so because the crowd is not feeling you. I'm trying to see what's wrong with you. They don't like you in this goddamn crowd. I had to come back on here because why is the crowd not? What did you do to make this whole crowd want me to kick you off this platform? What's going on, Felicia?
I mean, you can do that if it's your choice.
I want to hear from you. What brought you to the paperwork party?
I'm from Atlanta, so I've been following this story, and I just happened to be in here this morning when you were speaking about it. And then the young lady, when she came on, she was watching the trial, but most of the trial been without volume. So I came to join her to speak on the case.
Are you law enforcement?
Am I law enforcement?
Yes.
I am. You can go to my page. I'm a
Oh, man. Now watch this. Let me tell you something real
Okay.
quick, Queen. Something I learned over the years is when you ask somebody, are you law enforcement? The first word is no. But
I'm 56. I don't know that.
But you never don't know that. You're not supposed to know that. Hold on. I'm supposed to know that. You're not supposed to know that. I'm supposed to know that. I'm supposed to know that you're supposed to say no when I ask you that question. You didn't know that.
How old are you?
Don't worry about that. I think you're law enforcement now because you didn't even say no. And
I'm 56.
You agreeing with me now and saying, okay, I'm law enforcement. Okay, I'm law.
Okay, I mean, if that's what you want to say and believe.
Are you law enforcement? Are you law enforcement?
I am a registered nurse.
Oh my God! You have to be
you told me I'm supposed to say no.
You have to be law enforcement. You gotta be law enforcement. Hey.
You told me. I mean, no, but I want.
Okay, so look, the judge finna get ready to come back. Why don't? In a quick enough, don't give me no long ass drawn out story because we already think you law enforcement now. Why don't these people like you? It's damn near 30 people in the crowd that don't like you. You the first person I ever met that by 30 people saying, "Don't get her off the screen, get her off the." Why they don't like you?
You'll have to ask them.
What the fuck are you looking at? I'm this way. Look forward, ma'am. Look straight. I'm right in front of you. Look straight.
Respected you.
What are you looking at? Why are you looking to the right? What's that the right?
I'm looking at my second monitor.
Look at me. I'm on the first one. Look
straight. But I have to move it.
Look straight. I think you're in the ghetto.
Just a minute. Let me move.
Are you in the ghetto?
Let me move my
because we do 360s on her. I want to see how your surroundings are. Are you in the ghetto?
No, I'm downtown Atlanta in a very nice neighborhood. You can Google.
So you're not in a one-bedroom apartment?
No, you can Google.
Okay. I just want to know. I don't know. I just want to know. I'm just,
So I would like for you to meet me from your own point of view and don't listen to anything.
Hold on. I gotta listen to my people. You can't tell me not to listen to the crowd. You see what I'm saying? They here for me. I'm here for them. If a poison apple comes in, you can't tell me don't listen to my people. If a poison apple comes in, are you a poison apple, Queen Regina?
No, I introduced that theory today when I was speaking to the young lady. I'm a criminal justice major.
I understand. I don't give a damn about no criminal justice. You can kiss my ass with that. Are you law enforcement? That's really because you still haven't answered that one. Are you law enforcement?
Well, I'm going to go ahead and leave because I haven't disrespected
Hold on. Get up. I don't want to cuss you out. Bye, bitch. All right, y'all. She out of here, y'all. She's out of here. That bitch is gone. I don't know who she is. I know all y'all say, get her the fuck up out of here. Bye, bitch. I'm announcing I got shit to do. Everybody put in the crowd, bye, bitch. Bye, bitch. Bye, bitch. I don't know who this bitch is. All I know is my people said, get her the fuck up out of here. All right, gang, look, I got something to do, man. My people think I'm crazy over here because they really controlling these panels. They doing it. I want y'all to get a conversation going. The bitch is gone. The bitch is gone. Somebody say detectives. Do said bye, bitch. All right, let's see. This bitch is out of here, y'all. I don't know who the fuck she is, but she damn sure was a poisonous apple. They talking about poisonous fruits in this trial. Yeah, she was a poisonous fruit. The whole fucking crowd was like, get her the fuck up out of here. Bye, bitch. Deuces. Come on now. Bye, Felicia. Bye, Felicia. The fuck up out of here, man. Why the crowd don't like you, I don't know. But bye, bitch. And she couldn't even tell me. She started going down some this and that. I don't give a fuck about all that. Why is all these people in the crowd saying you a bitch? Get you up out of here. All right, now we know she's a poisonous apple. She tried to go down the long thing. She tried to sneak up on my panel. You can't sneak up on the panel. Get the fuck up out of here. All right, that bitch is gone, y'all. I appreciate that shot. Now, that's how you sniff out a fed. You see that? When we work together, y'all, we can have a beautiful channel. All we got to do is work together. I wasn't even in here. My people telling me, hey, man, this. I had to come see what was going on. Bye, bitch. As soon as I lead a panel to the paperwork part and I don't come to the panel, somebody creep up on the panel. See, I'm finna try a new thing. I'm finna try a new thing where sometimes I just don't come to the panel. And y'all can have the panel and watch these cases. And my engineers can work it. And y'all get a conversation going just like we do in the clubhouse. Just like we do in the clubhouse. All right? So look, the line is open. You can come up to the top. We got, what, 5-minute break. We waiting on my boy to get back up in this motherfucker, man. He doing his thing. He doing his thing. Sick'em say, bro, must be paranoid. Shut the fuck up, nigga. Let me see, PW, she making me my ass. I just, I've seen a lot of comments, but it was more like, okay, now I'm saying damn near 3, 4, 5, 6, 7, 8. It's like, I'm like, oh hell nah. Let me go see what's going on right quick. Let me go check on this situation right quick. All right. So look, gang, look like, let me see. Let me put the go ahead and put that back on real quick for the people. All right. So now the volume is back on. All right. Look like the judge should be coming back in here in a minute. What's up with it, man? Look like the judge coming in. What's up, Kimberly, man? Come on, me. What you think about this, Kimberly, man? What's going on with Young Thug, man? Look like Thug finna go to the house, man.
Hey, man, you should be a comedian, man. I ain't lying, bro. You're a funny dude, bro. Well, I swear to God. Talking about Young Thug with mustard, man. You wrong for that, man.
He sniffing himself. Sniff.
Hey, man.
I may end my career as a comedian. Who knows? What's up with it, though, Kimberly?
Hey, man, I don't know, man. I'm getting mixed signals from that judge, man.
Let me tell you some real shit. Hold on, Kimberly. Let me tell you some real shit. I beat a case a long time ago. All right. And the lawyer I paid, I gave her $10,000. She beat the fuck out this case. The same shit happened to me. And what it's called a suppression hearing. We had a suppression hearing. What happened is I got pulled over for running a stop sign. I got pulled over, right? And when I got pulled over, they found a shitload of guns in the car, weed, everything, right? And they took my shit, cell phones and all. When I paid this attorney, the attorney had a suppression hearing the next week, and the judge found that I didn't run the stop sign because this is what they said. They said that the cameras on top of the car had a 30-second delay, which means that once they cut the lights on, it goes back 30 seconds. You see what I'm saying?
Yeah.
So they didn't have the video of me running the stop sign because right when they cut, you see what I'm saying? And we was like, where's the video of me running the stop sign? And they talking about, well, the 30-second delay was cut down to a 5-second delay.
Oh, yeah. They got to throw that whole shit out.
It's called the fruits of the tree. Since anything that happened after you pulled me over, you can't use it. They had to give me my cell phone back. They had to give me every fucking thing back. Bro, I done been through these suppression hearings before. Trust me, bro. I done got a lot of cases thrown out.
Hey, bro, so did they give you a bond when they first locked you up?
They always give you a bond. You got to get a bond. But, bro, he's going home. Trust me, I'm listening to this case. He going home today. If he not going home, whatever this hearing is, they about to throw this shit out. Because first of all,
making a lot of sense, bro.
You see what I'm saying?
You know what the fuck you talking about.
Oh, yeah. He definitely going home. It's called a suppression hearing. Anything will be suppressed afterwards. When they pulled me up for running that stop sign, they said that they was in a different cruiser. The 30-second delay wasn't working. All that bullshit. The judge threw it out. They had to give me all my shit back, my guns, everything. The only thing I didn't get back was the weed. All right. And they didn't really take that much. You see what I'm saying? On that particular, but they didn't get it back. They had they talking about they was trying to, you know what they had did? They had already gave my cell phone over to a detective and he was working on another case trying to get me on. You get it? That's why they stole the cell phone. Yeah. So when the judge had on the suppression hearing threw that bitch out, that tanked that other case that they was working on. It knocked everything down. I'm telling you, trust me, bro.
You was able to get your phone back too, bro?
I got everything back, bro. Bro, you know how much shit I done got back? Nigga, I done got all type of shit back. Nigga, I done got guns, nigga, ammo, all type of shit. Nigga, I done got more than 20, 30 guns back from the police, nigga.
Damn.
Yeah, nigga, you got me fucked up, nigga. Yeah, they gotta get your shit back. They got to. But I'm telling you, I'm telling you, I'm listening to this shit, gang. I'm 90% sure that the judge is going to rule in the favor of Thugger, because first of all, they didn't have a warrant. The warrant wasn't certified. You see what I'm saying? You can wake a judge up in the middle of the night and get a warrant signed. They didn't have a certified warrant. They took his shit and they tried to use on another case. You see how she said, well, we still investigating this right now, so why would we give him his shit back? Bitch, because you didn't have a warrant. Right. I don't give a fuck about your investigation, bitch. You took his shit illegally for your investigation. You didn't have a warrant. Thugger's going home. And we just been listening to this shit, what, 20 minutes? Come on, man. These people are fucking crazy, y'all.
Yeah, bro. You right. I swear to God, you right.
And I swear to God, right when they said they didn't have a warrant, I'm like, hold up.
Yeah.
Hold up.
And if they can't show that warrant, bro, that's enough to throw this shit out.
You didn't even have a warrant. What the fuck are you talking about? So first of all, this is what's going on. They investigating Thugger. So let's go send his shit. Let's send his shit to the what's name, you see what I'm saying, to get his phone broken into. And by that time, we'll convince the judge to let us get into the shit. No. Yeah. That's called backwards. You go get a warrant first, then go take his shit. You don't go take his shit and then go seek a warrant. That's exactly, watch this, gang. I'm finna teach y'all some shit. What's happening to Thugger is, oh my God, y'all. That's exactly what's happening to DJ Pat. Remember, y'all, they put a warrant out for his arrest and then put a search warrant out. The same shit's finna go down in the future with DJ Pat, bro. Watch. They do it all. The reason they do this shit backwards, y'all, is so they think they can backtrack. When you got a judge that's not gonna let you backtrack, you're fucked. You see what I'm saying? And that's what all prosecutors try to do. They go take your shit and then backtrack. When you supposed you're supposed to go get the right paperwork. After you get the right paperwork, then you can go take their shit. You can't take their shit and then go ask the judge, can you go into the shit you stole? That's exactly what they do. Watch this, gang. I'm finna give y'all an example. I'm finna teach y'all something real quick. Y'all know DJ Pat. Remember, they got an arrest warrant for DJ Pat. Right when they got an arrest warrant, what did they take out of his pocket, y'all? They took the cell phone. Remember when they took DJ Pat's cell phone? What did they do the next day? Then they went and got a search warrant for the cell phone. I'm finna say it one more time, gang. I want y'all to stay with me on this. Think about this. When they got an arrest warrant for DJ Pat, they got an arrest warrant and they went and arrested him. When they arrested him, they found a cell phone and they found money on him. After they found the cell phone, they went to the judge and got a search warrant for the cell phone. Now, if you think that's not the same shit going on in Thugger court, you can kiss my ass. If Thugger leave, DJ Pat gonna leave. I'm telling y'all how the game work. All right, gang, y'all think I'm bullshit. They did not have a search warrant for his car. They didn't have a search warrant for his cell phone until they arrested DJ Pat. Same shit going on with Thugger, man. And in Thugger case, they didn't even go get a search warrant. They was waiting for later on after another investigation, and they had already stole his shit and was using it for the new investigation.
You can't do that, bro. You can't do that.
Can't do that. The judge finna come back and rule for Thugger. Young Thug finna he you know what? Young Thug coming home, man. Shout out to the game, man. He definitely need to come home and wash his hair because he's dirty. He smell like musty doo-doo. He smell like musty doo-doo. Do I got time to play my theme song real quick? Like the judge may be coming back. That nigga back there taking the shit. Let's see if I got time to play the theme song, man. You know, we jump right into it, gang, real quick. The lights should match the views, gang. I don't want to run nobody out, but let's go. I'm looking at the screen, gang. I ain't gonna hold you.
What's up, paperwork party? Gang, 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 gang.
Get the lights up, gang.
Paperwork gang, gang, gang.
Get the lights
like button.
up.
Let's go. When you come in. Lego, hit the like button.
Lego.
Hit the like button.
Get the
Hit the
lights
like
up,
button.
man.
My likes should match my views.
Right, man.
Hit the like button. Hit the like
We
button.
on round
Hit the
two,
like
guys.
button. My likes. So when you come in, hit the like button. What's up? My likes should match my views. Hit the share button. My likes should match my views. Hit the notification. Let go. Let go. My likes should match my views. Come on, y'all. Yeah. My likes should match my views. Lego, hit the like button. Hit the like button. Yeah. Hit the like button. My likes should match my views. Hit the like button. I hit the like button. Come on, hit the like button. My likes should match my views. Lego, Lego. My likes should match my views. Let's go. My likes should match my views. My likes should match my views. Lego, Lego. My likes should match my views. Hit the like button. What's up, paperwork gang? Gang, gang, gang. Yeah. Hit the like button when you come in. Hit the like, notification, man. Notification, man. Cash out, let's go, y'all. Hit the cash out. Hit the cash out. Hit the cash out, man. Or get your ass out. Let go. Hit the cash out. Hit the cash out. Hit the cash out. Or get your ass out. Let go. Hit the cash out. Hit the cash out. Hit the cash out. Or get your ass out. Hit the cash out. Hit the cash out. Hit the cash out. Or get your ass out. Come on, y'all. Or get your ass out. Hit the cash out, man. Or get your ass out. And just get out, man. Come on. Or get your ass out. Donate to the channel. Or get your ass out. Hit the cash out. Hit the cash out. Hit the cash out. Or get your ass out. Hit the cash out. Come on, y'all. Hit the cash out. Hit the cash out. Or get your ass out. What's up, paperwork party? It's paperwork party, paperwork gang, gang, gang. Hit the like button when you come in. Let go. Hit the likes or get the hell off my page. Paperwork party. I done stepped up on the stage with no script laid. Come off the fade on this page. Riding with a 12 gauge, I'm spilling the lemonade. My helicopter got blazed, a condominium with base. They ask my real age, I'm chilling within the squade. Hit the like button. Hit the cash app, donate, don't hate. I'm in Mexico sitting on wait. Hit the like button or get the hell up off my page. Paperwork party. I done stepped up on the stage with no script laid. Come off the fade on this page. I'm riding with a 12 gauge. I'm spilling the lemonade. My helicopter got blades, a condominium with maze. They ask my real age. I'm chilling within the square. Hit the like button. Hit the cash out. Donate, don't hate. I'm in Mexico sitting on wait.
Gang, 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 man. Make sure you hit the like button when you come in. My likes should match my views. It's definitely going down, man. The judge is taking a shit. All right? That nigga said 5 minutes. That nigga, and he taking one of them shits, he got to, that's what he be eating too much chocolate, y'all. He be eating too many of them Butterfingers. He trying to squeeze that one out. You know how you try to squeeze that bitch out real quick because you got to be somewhere, nigga. You knew you had to take a shit before you came in this trial, nigga. You know Thug about to go home, man. Hey, if he not about to go home, this particular hearing, he won. So I don't know if he going home, but he won this one, gang. I'm just telling you what I see. It look like he won it. All right? Ain't no way in hell your ass gonna not have a warrant. And no, you have to have a warrant certified, signed by a judge. Ain't no way in hell that this nigga is not this. No, I'm sorry, gang. I'm sorry. I thought these prosecutors knew what the fuck they was doing. How the fuck you gonna come out a nigga without a warrant? That judge is not stupid. The prosecution is crazy, y'all. Come on now. This nigga didn't have a warrant and they took all his shit and they kept it on a separate investigation. He is going to beat this hearing. All right? All right, gang? Hey, let me see my boy WT. Come off of mute, WT. Yeah. What you think about this, man? Talk to me, man. What's going on, man? They think we stupid, WT. What's going on?
Yeah, all hope was lost at first, but we coming back around now. Yeah, they done messed up big time, boy. Washington, come on in. Houston has been compromised.
My bad, gang. My bad. All right, so here he come. He coming back. check this out. Appreciate that, Donald Peoples. Donald Peoples in the house, definitely going down, man. Appreciate the super sticker. The judge just finished taking a shit. I appreciate the super sticker. I think he's wiping right now, gang. He got them new baby wipes. He got them judge wipes. Them judge wipes. It's going down, man. Somebody say, keep talking. They laughing. Shout out to Donald Peoples, man. Appreciate the super sticker. Donald Peoples in the house, man. It's going down, man. All right, so look. We about to get back into it. Y'all know this round two, man. We was early this morning. Go back and check out the video from early this morning. For those that don't know, talking about the governor talking to the judge. Yeah, I most definitely believe that. All right, so look, for those that don't know, man, we got a new show called Court TV with Paperwork Party every morning. Court TV with Paperwork Party every morning. You see what I'm saying? We got Killer Can came up a little while ago. We're going to make sure everybody get a discussion on. I may not be on this panel well, I will be on here every day. I'm just saying I may dip out just to see if y'all gonna stay on her and talk. Y'all gonna be looking out crazy like y'all know what's going on. Look, we got Kimberly, man. We got WT. This is everybody's paperwork channel. This ain't just my channel. All right, we all gonna get up here and talk and respect each other on Court TV with Paperwork Party. Because every day we're gonna be looking at these, and y'all gonna learn a lot on this channel. I'm gonna tell y'all gonna learn so much looking at these court cases. Because what I just told y'all was gold. I got pulled over on the stop sign, all right? They found so much shit. I'm telling you, them guns, boy, they was on my ass and my phone. They went through my phone. They was on my ass. But guess what? They couldn't use none of that shit. They couldn't use none of that shit because they didn't even have the video from when they stopped me on the stop sign to see if I really ran the stop sign.
Yeah,
all
when
right?
they ain't got that footage, bro, they fuck.
They fuck. Boy, the judge threw that bitch so far, and it's crazy because when the judge threw that bitch out, it was on November I think it was November the 15th on Veterans Day. It was on November the 11th, I think, on a Veterans Day. It was, and that was, I always call it the Veterans Day trial because I beat the fuck out that bitch. All right, come on, y'all, it's going down. Yeah, somebody said bye, Felicia. Yeah, Felicia been gone. All right, y'all, here come a big boo-booing ass, take a shit ass judge wipes. That nigga still shitting. He still ain't, look at him, y'all. He still ain't came back. He still ain't came back, man. I hope he washed his hands. Man. You know, a lot of people
Gave him the bubble guts paperwork.
Nah, he know. I'm gonna tell you what gave him the bubble guts. The fact that this black man is in jail being ridiculed without a search warrant. That's like the main core. Like literally, it's certain things you have to have something to do something. You have to have a driver's license to drive.
Yes,
all right?
sir.
That's period. That's like the main core. You have to have a search warrant to go in somebody's house. Like, come on, police. Y'all actually thought y'all was gonna get Young Thugger without a search warrant? And it was so easy, Kimberly, to get a search warrant. Kimberly, come on, Kimberly.
Right.
It don't take them niggas 30 minutes to get a search warrant signed.
I felt like they was racing against the clock and felt like they couldn't wait for it.
But what was it? That's what I'm saying. Like, what was they racing against?
Yeah, maybe the feds had their own investigation.
The feds must, because the feds ain't this sloppy. This some state ass Atlanta bullshit. The feds don't have a search warrant, certified, ready to go. I cannot believe the state police didn't have a search warrant. Yeah, he getting, and you know what? What's the name snitched for no reason? If what's the name snitched to get out on probation, I'm gonna go read his plea now. Fuck this. Because if that nigga snitched for no reason and Thugger finna get out, this is some crazy shit. All right, here come judge. I'm gonna let you talk, Kimberly. The judge coming back in. What you gotta say real quick before they cut the volume on, Kimberly?
Shoot, man. I think he might have turned a new leaf. Paperwork, his whole energy might change. He might see the light. What you think?
Nah, I think he's going home. I think he's going home, gang.
And listen to that new Young Thug gospel album.
And I'm gonna tell y'all why I think he's going home. Like I said, I've already beat a suppression hearing. All right, I've already beat a suppression hearing. I know how they work. Nigga, anything afterwards, they throw everything out. If you can't prove I ran a stop sign, all the guns you took out my car, all the weed, they throw it out because you can't prove I ran the stop sign. The reason you pulled me over in the first place. So guess what? The reason they got all his shit was because they went in his house with no search warrant. Yes, Gunner's about to beat this one, y'all. And I'm calling it right now.
Yeah, that's illegal, bro. You can't do that shit.
What's up with it? We on your ass. What you think, man, for the judge come back? What you think? He about to
I ain't
rule?
gonna lie. All that whooping that fucking DA was doing, whoever the fuck she was, she had more than enough time. He been sitting down for a minute.
Come on.
And you ain't got your shit in order. This is your fault.
It's your fault.
Can't wait till that new gun. I can't wait till that new Young Thug gospel album come out.
Hey, wait a minute, hold on. Do you know what her excuse was? She said that the other judge did not give him his cell phone back, so this judge shouldn't. The other judge didn't give him his cell phone back because the fact that a search warrant didn't even come up. This judge, this lawyer was smart enough to look to see that y'all motherfuckers didn't even have a search warrant, you fuck faces. Always breaking in black people's houses with no search warrants. This shit ain't even new.
Dumbass.
Here come the volume, gang. Yeah, they some dumbasses. That's what I call them. Gonna break a nigga house with no search warrant and think he a superstar. Come on, Gunner, go on and smile. You finna go take a bath, nigga. Gunner finna get him a bath in, y'all. He about to beat this. Gunner finna beat this one. Come on, search warrant. You can't fuck up a nigga without you gotta have a search warrant to go in a nigga house. No search warrant, no entry. Fuck you. Give a fuck about you investigating, nigga. Shit.
Judge seemed mad as fuck, like y'all brought me this bullshit.
Found a loophole.
That nigga said the judge gonna let it slide. He better not let it slide. He better not. That nigga say the judge gonna let it slide. Boy, you better not let this one slide, Judge. Hell nah. Fuck that let it slide shit, nigga. You see them niggas ain't got no search warrant, nigga. You don't know what the fuck you read, nigga. I don't know what you read, but them niggas ain't had no search warrant, Judge. You better not let this one slide, you little black motherfucker.
Case dismissed.
Hey, he know he can't let this one slide. No search warrant. What if somebody ran to your house with no search warrant? You already know, nigga. You can't let this one slide. If a tree bears fruit, that fruit spoils everything. Let's go.
Thanks.
He reading everything that they found in there.
He look like he's trying to find a way to screw him, but he's like, fuck.
Yeah.
You can read his whole Harvard degree in his hand right now.
That also let us know that he went to the back to go take a shit because he should have went back there and started reading, right? What did you go back to the back for? You get it? He supposed to have been reading in the back and come up with a decision and come to the front. He went to the back and took a shit, gang, and now he's reading. He's doing what he's supposed to be doing when he went to the back to his office. When you went to your office, Judge, that's what you should have been doing, reading and deliberating. I'm about to go deliberate. Nah, nigga, you went to go shit. Now you're deliberating in front of our eyes. You've already shitted. You wiped your nasty ass, Judge. You didn't flush. They made you go back and flush. They was like, Judge, you didn't flush. He was like, bro, what's up with all these turds you leaving, man? What's good, Judge?
Come on, man.
And now he's deliberating. That
You can
nigga
see his law degree through his forehead.
He know what he doing, y'all. That nigga took a big ass shit. Now he's deliberating in front of us. Nigga, you been deliberating in the back, nigga. We don't want to see you deliberate. This is what you call deliberation, gang. Exactly what the fuck he doing right now. Nigga, what you walk to the back for? I'm telling y'all, either you went to the back to take a shit or you went to the back to go fart. And you had to stay back there a little longer because you got that robe on. You had to make sure all the fart was out of your robe.
Come on, man.
Rio said, I'm sick of you. Hey, he didn't take a shit, y'all. He went to go fart. He didn't take a shit. He went to go fart. He had to take his robe off and dust his robe out. Cause that courthouse is already stinky.
Already smelling like Young Thug armpits.
Yeah, hey, Young Thug stinks. The courthouse stinks. Young Thug musty.
He went to go receive a fax. Somebody faxed him them papers.
Oh, for real? Nah, you might be right about that. You might, but he definitely took a shit. I just hope he licking his fingers. Bro, did you wash your hands, Judge? Did y'all see him lick his thumb to turn that page? The judge, man, you know what? That's a nasty courtroom, my nigga. The judge nasty, Young Thug nasty, everybody nasty in that courtroom.
Yeah, he just received them papers fresh off the fax. Somebody he ain't had that when the court case started. He went to get that fax.
Hey, you think they sent him a warrant? Like here's the real search warrant. Yeah. They couldn't have sent him. They kept saying it wasn't a warrant. It wasn't a warrant, and then the prosecution never verified that it was a warrant. So how can a warrant?
Because they can't tamper with evidence. Them dates got to match up.
Nah, for real. Yeah, nah, you right about that. The dates got to match up. The paperwork got to match up. You're 100% about that.
Yes, sir.
Let me see. Shout out to KK, man. Appreciate that, KK. KK in the house, man. Appreciate KK supporting the paperwork party today. All right, you know how we doing it today. All right, shout out to the game, man. I'm definitely in two different places at one time right now, y'all.
Look, man, I'm driving 70 on the freeway right now, and there's a girl next to me. Oh, women are very, very talented. She over here doing her makeup. She going at least 80. She doing her makeup in the mirror.
You want to show
in California? This.
I mean, you can show.
I'm trying to catch up with her without getting in trouble. I ain't finna play no. I'm in a work car.
Just saying, if you want to show us, you can show us because we definitely like to see that.
Nah, she just got off. She just got off. But fuck, I should have did it.
Yeah, you got to be careful. She doing her makeup. I seen the bitch eating a double cheeseburger before driving. I'm talking about.
Man.
I'm talking about she was a professional, nigga. She was eating the fuck out that damn burger. She had a drink. She had three hands, my nigga. She had a drink in one hand, burger in one hand, steering wheel in the other hand. I seen a big ass bitch eating a double cheeseburger and drinking a soft drink. She had three fucking arms. One was holding the steering wheel. One was holding the double cheeseburger, and the other one was holding the drink.
She must have had the fries. She must have had the fries between her knuckles.
You know what? She could have had another arm on her back for the fries because I thought I seen some fries coming out of nowhere at the top. So maybe she did have about 4-5 arms because that bitch, you know what? People can eat and drive. I can understand that. People know how to eat and drive, but not no fucking full course meal type shit. Like, I can understand you got a little burger in your hand, but damn, bitch, you doing treat bitch juggling that shit. Bitch got burgers, fries. She got
finger food.
Pie. I heard that pie ain't 99 cents. Is that pie not 99 cents no more? Or is it, how much is that pie?
They probably added 50 cents to that bitch.
150 now, yeah. You know, McDonald's be digging in niggas, boy. You think you get a deal from McDonald's? They digging your ass, nigga.
Some good ass pies, though.
Do y'all remember when that 99 cent shit came out? It was like, when they first had a 99 cent menu, I remember that. I was like, why not just say $1 menu? Why would you say 99 cents? Because 99 cents makes you think that it's like below $1, but that bitch always came out to like 107 or 110. It's like, nigga, I'm gonna pay $1 any motherfucking way. I hate taxes. Shout out to the game, man. Yeah, I don't know what he reading, y'all, but all right, y'all. Now I'm down to 80%. That nigga been reading too damn long. I'm down to 80%. I think Thugger can beat this hearing right here, y'all, but that nigga reading too long. Uh-oh, here go the volume. Here go the volume, gang. We about to get to it.
Wow, that's loud as hell. Sorry, gang. I had to go get the shorty from school. But that shit loud as hell.
Nah, I'm about to bet. Why well say her belly was driving. The one with the double cheeseburger, the drink. Will's good with the family. She prosecuted my cousin murder 2000. Son of Adabon. Remember when they had 49 burger? You ain't gonna ever see that no more. Ever since gas flew up, you'll never see another 49 burger. If you see a 49-cent cheeseburger, it ain't meat. Don't eat that shit. If you see a 49-cent cheeseburger, don't eat it. It's not meat. All right, it's not. All right, gang, we taking a break real quick. All right, the judge is about to come back with his what's the name? I'm about to go on mute, man. We got Killer Cam back up. I ain't supposed to be on the mic right now, but I had to come on the mic to get old girl up out of here. We had a poisonous apple that came in. Her name was whatever the fuck her name was.
That's who was talking to me. The one. That's why they kept saying I told you she trouble and da 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 da. The lady who was talking to me.
Yeah, who the fuck was she? I was trying to figure out who the fuck she was. She definitely came onto the platform, but
and she turned her camera on and everything. I didn't catch her name. Her name. Huh?
Don't say her name. We know shit. We just kicked her off while you was gone. All right, so we just kicked off, so ship out of here. All right, so look, I'm gonna let y'all get a conversation going on real quick. We got Killer Cam back. We got I think my boy WT was talking. No, that was Kimberly. My boy Kimberly was talking. We got WT and we got Mr. We on your ass. I'm about to go on mute. I'm gonna let y'all get a conversation. Kimberly, you got the flow real quick. What do you think about this? Now I'm at 80%, bro, because the judge is doing too much right now. All right, so what's going on?
Shoot, man. I would like to ask the panel, man, what do y'all think he took so long for? What was going on back there? Was he taking a shit or was he really deliberating?
Hey, Smoke is taking a shit. I think they
I ain't
back
gonna
there
lie.
deliberating about some shit.
I think he's trying to make the shit make sense.
I like how you put that.
What do y'all think about, like, damn, if he get off of this, damn, Gunner, you just took that on the chin for nothing?
Well,
How do y'all think that affect Gunner in the streets?
I don't think it would be for nothing. I think he was just thinking about his own personal freedom and the best deal for him, you know.
But damn, look how fast it happened. Gunner get out. He did that shit yesterday, and then let's just hypothetically say Thug get off, and that's today. It's like, damn, that's barely even 24 hours.
Yeah, maybe they did it on purpose like that.
And they,
as far as the dates.
Slime.
I don't know, man. I think we'll see, though. We about to see. It's hard reading the energy from this judge, man. I can't really read his energy like that.
I can read his energy. He's still constipated. He wish he would have stayed on that damn toilet. He got up too early, man. He got up too early. All right, so do anybody got any information on, real quick, while we are talking about Young Thugger? Where that nigga? This nigga right here. Do anybody got any information on him? Did he really commit suicide, gang? Or
Man, and I was trying to look to find some shit on this man. He did a very, very long live, like right before he went, or did a video right before he passed, and he was talking about how, we didn't have justice for a lot of our black young people who have been killed. He was talking about like Breonna Taylor and Trayvon Martin, and he just started listing off all the different young black people who have been killed because they had found, I guess, the person who did whatever to that little girl, the little white little girl, and he was like, great justice for her. But what about, all of us that's been killed and hurt and whatnot? And then that was like his last post, and he looked like he had so much on him. So I'm not sure. I know he went to a hotel to kill himself.
Every time somebody speak out, they end up committing suicide. Yeah, right. He spoke out. Now he committed suicide. That's bullshit.
Why they always go to a hotel to do shit? Damn, you spending your money to kill yourself? You can kill yourself freely somewhere else.
What was going on with the hotel? We on your ass?
That hotel looked like a little, just like a little rinky dink little hotel. They said the lady said she seen blood or whatever, and he was supposed to check out, and he didn't check out. So when they went into the room, they seen blood, and she said that she seen him laying down. Sorry.
No, I was just saying, why is it with most of these people that kill themselves, that say it was suicide, it happens in hotels. They go spend their money to kill themselves when there's so many free places to do it, especially when you got that type of stature. It's just it just makes me think. But I'm not trying to be a conspiracy theorist.
Man, hell nah. And this bitch right here, she killed Anne Hatch too. Look, Ellen DeGeneres killing everybody that know about her and that Wayfair shit. Everybody know about her and that other shit. She killing them off, y'all.
I wouldn't put it past it, man. Blood
I agree
sacrifice.
with that, bro.
And the best sacrifice to put out there is a black man or a black person.
And you see how Anne Hatch went cuckoo for Cocoa Puffs the way they set her up. Like they took control of her little Mini Cooper and
Bro,
everything.
think about this game. Whenever they kill a black person, they shoot them up. Like Takeoff, like Dolph, they shot him up. Whenever they kill a white person or a white sacrifice, it's always like some suicide bullshit. How did Anne Hatch drive into a fucking house and commit suicide? Come on, that's bullshit. And now, not even 2 months later, this nigga commit suicide. All that shit go back to Ellen. Ellen is trying to clear these niggas so they won't testify in court against her ass. Ellen, you a bitch. He pointing at you in this picture because he letting the world know you the one that killed him, bitch.
And driving into a house is not even 100% guaranteed that you're gonna die. There's so many things that a car can save you that don't even seem logical. Like that's the choice
She did
that she took.
She rented her car and ran into a damn abandoned house, and they tried to make it like somebody was living there.
This shit is crazy.
And it's gonna be hard to do this one because the same way he died, see them coroners in fucking LA, man, them motherfuckers be paid the fuck off. Ellen, you a bitch. You a bitch. And then Ellen trying to act like she ain't got no, my bad, Kim, I'm finna let you have, but Ellen be trying to act like she's just a cool person, she ain't got no enemies in the world, this and that. Ellen trying to wipe out all the witnesses, y'all. Every witness that can testify against Ellen, she trying to wipe out all the witnesses, y'all. That's 2 people in 2 months. We may have to look into this nigga shit, man. You got the flow, Kimberly.
Hey, man, I agree with everything you just said, bro. But, man, be careful, man. You talking about a different type of people now, man. You get into Ellen shit, bro.
So you saying Ellen got more power than Prince? Let's go. Let's go, nigga.
Hell yeah, she got more power than
Oh, shit.
Yeah,
oh, shit.
Yeah, boy.
That shit
Can I ask y'all a question? Outside of the Ellen DeGeneres show, what is she known for? Like, why is she so popular? I don't even. Like,
well, my connection.
Was she on like one of those soap operas?
Eating pussy.
She used to be like an actor or some actress or something, wasn't she?
She well connected with the Clintons.
She was an actress. She used to have her own show like Ellen, like a little like series.
Yeah, she had influence like Oprah, bro, but for like the LGBT community, you know what I'm saying?
But yeah, she was on she had her own little series and shows where she was an actress.
Yeah.
Yeah,
she one of like the first ones that get married to a female too. She like one of the first legal marriages in United States for that.
They gotta start a movie on how to kill a brother. This
All right, we
way too
got
many brothers dying.
Rebel Pac, man. Rebel Pac. What's up, Rebel Pac, man? Talk to us, man. What you want to add to this, Rebel Pac?
It might unplug it.
No, you got to take your volume. Oh no, matter of fact, your volume is not even plugged in. Your volume not plugged in, Rebel Pac. Get your volume plugged in. You off for mute, but we cannot hear you. All right, Rebel Pac is getting that together. All right, let's see who else we got. We got WT, we got Mr. We on Your Ass, we got Kimberly, and we got Killer Can. We definitely wait on the judge, y'all. I'm looking at these other two channels. The judge ain't on now one of them. So stay with the paperwork party. We'll definitely get it to you.
Hopefully it don't unplug it. Hopefully it don't unplug it. Hopefully it don't unplug it. Oh shit, sorry. But nah, y'all know Ellen, she did some weird shit because she was not out. She wasn't always out with her sexuality neither.
So was she on the alphabet community or something?
Yeah, she advocated to push that through with Obama, because you know Obama passed that.
Okay, so that L and LGBT means Ellen. Okay, I got you.
Yeah.
And then she got a black man to put her on. That's gangster.
Yeah.
Ellen a bitch. Shout out to Rebel. Did you get your volume, Rebel?
Hey man, paperwork. You pursue Ellen, man. That's a whole nother situation.
Ellen, nigga, I beat the boy. You know what I do to Ellen? I got some I stick some females on Ellen. I know how to get Ellen, man. Come on now. I know how to get Ellen, man. You think I'm gonna let Ellen get me? Nigga, I got some of the most finest females. Ellen will fall to my feet when she see me, nigga. I had a more big booty female come up to Ellen, nigga. Ellen wouldn't be able to do nothing, nigga. She'll fall down and tell me everything. I'll be like, Ellen, you see this big piece of ass over here? Oh, paperwork. I can tell you what you want to know, paperwork. What you want, Ellen? You want an Ann Hatch? I got an Ann Hatch over here, too. What you want? I got these big booty bitches for Ellen. No, I'm fucking with y'all. Hey, it's back on, gang. We back in the courtroom, gang. He's scared of Ellen. That's my boy, but Kimberly's scared of Ellen. Nigga, are you scared of, nigga, Young Thugger? I'm scared of I ain't scared of Young Thugger. You know what? I can be more scared of Young Thugger than Ellen. Your case, you scared of Ellen more than Young Thugger. You know what? You may be on to something, Kimberly. You fucking may be on to something. All right? I'm gonna leave Ellen alone.
I would, bro.
Nah, fuck that bitch. I'm coming
Ain't
out.
nobody scared of Ellen ass.
Shit.
Fuck Ellen.
If you kill Twitch, we on your ass, Ellen. Bitch. I'm gonna bring some big booty bitches with me too when I come get you, bitch. I know how to get you. Don't fuck with me, Ellen.
Paperwork. Say that shit with your chest, man. You got FBI on your ass. She can't be more powerful than the FBI.
Why did you
say it with your chest?
I know.
She
wait, where the volume at? Hold on. Let me volume. Oh, okay.
Attached and in with the state's motion for reconsideration. I can't remember what number it is right now.
Your Honor, we just asked if we could just admit it as a separate exhibit to this hearing. It's certified. It's self-authenticating.
Well, it's already in evidence. And the last one is already in
Well, any objection to that one, the search warrant, arrest warrant, I should say, Mr. Steele.
I will lodge an objection at this point. Yes, sir.
Basis?
Basis is that it is attempting to relitigate something that should have been done before. It has no bearing on this motion whatsoever.
Your Honor, we would like a complete record, and if it's already, as Mr. Steele says in the record, we don't see the harm in simply perfecting the record with a self-authenticating document.
Well, the issue is you didn't introduce it at the hearing in 2017. That was the basis for the ruling for Judge Newkirk. So I don't see why I would need to accept it right now. because I'm going to rely upon Judge Newkirk's ruling.
We'd just like to have it in the record, so we may use it if we, just to complete the record, Your Honor, not for the purposes of argument in this particular instance. Should the court wish to rule with us and have a hearing on this, then we'd enter it separately, but for the purposes of the record, we'd seek to introduce it right now.
Let me see it, please.
Yes, Your Honor. It's certified.
All right, Mr. Steele, I'm going to admit over your objection, okay? It states one for purpose of the motion.
And Your Honor, then we'd also just move to admit a certified copy of the search warrant to enter the defendant's home. This was actually attached as an exhibit to the previous transcript. Again, we'd just like to admit this for the purposes of perfecting the record. It's a certified copy.
Okay.
I'll object. It's attached as Court's Exhibit number 2, pages 57, 58.
All right.
9, it's already, the court admitted that as an exhibit earlier today.
Oh, the transcript was admitted, Your Honor, but we'd like to admit the certified.
Okay, all right. The certified copy states 2 for purpose of the motion?
Yes, sir.
Okay, all right.
As Mr. Steele stated, the other one was D10.
Yeah, I've got, that's admitted already.
Is that certified, Mr. Steele? No.
But it was admitted in the hearing on the 17th of November.
May we also tender this as a certified copy of that search warrant, though? As states 3.
All right, any objection? Or same objection, sir?
Yes, sir.
Okay, all right, states 3 is admitted for purposes of the motion.
Thank you, Your Honor.
No, I'm good, I'm good. Anything else? Anything else in terms of the states and states 1, 2, or 3 for purpose of motion?
Well, Your Honor, we would ask to have a hearing to have the opportunity to show that lawful entry into the house and the search warrant to the phone, but we weren't sure if the court was going to allow us to do that. But if we are, we're ready to do that. We'd like to do that.
I'm not inclined to have a hearing on this, okay? Because, and here's why. Judge Newkirk's ruling fairly contains some principles of criminal procedure, and even though you've admitted these particular items for purposes of the record, which would supplant bias and some and would make the issue of your, that's one argument you could make in terms of the sufficiency of the arrest warrant and the search warrant. The issue still becomes is that that issue was decided by Judge Newkirk earlier, and you all from the state have not given me any. You're still not getting over 17-5-30. There still would be no reason for you not to have returned this property. There's nothing in law that would indicate to the court that you had the right to, to maintain and continue to investigate on those particular items that were taken. But so that's why I don't need to have a hearing necessarily on it, on that particular issue. So with that,
Your Honor, would the court permit the states, we would like to proffer what the evidence would show, were we permitted to introduce the witnesses that we have. As the court...
I'm I'm okay with that. I'm okay with you all. But I mean, the warrants would supplant, the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But still the problem that you're going to have is that 17-5-30 would have required you to still return that particular property. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, you know, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you know, you're getting a second bite at the apple, and that particular circumstance. That's why the legislature makes some very specific issues about 17-5-25, which is execution of warrants, 17-5-30, which is motions to suppress, and then 17 17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now if you've got another argument as to why you didn't, other than why you didn't return his property, but you would have still needed to return it. I mean, you didn't go forward with that prosecution. If you've got some other case law you want me to look at, but it's pretty clear. The reason that the legislature enacted this statute is because they didn't want the state. Yeah, and Mr. Steele's argument is, and just hear me out, you didn't have a valid arrest warrant to begin with. Now you got one, but you didn't have one when you had one in front of Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with, because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele and his motions asked for suppression of anything that was taken in the house. So the marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you asking me to kind of, okay, well, the marijuana's over here, that's fine, but he didn't suppress the other stuff, we can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.
Your Honor, thank you. And respectfully, the issue of whether or not the state had a valid arrest warrant is actually proven with respect to, did we have one with the certified document that the court has that the state has tendered as evidence. So it's not a matter that the state did not have lawful authority to enter into the home.
But you didn't have it at the time that Mr. Steele.
We had the search warrant. That search warrant, that certified document that is in evidence, Your Honor, has a date on it. It was signed and filed well before Mr. Steele made that motion, and it was a part of the record of the clerk of court.
But you all didn't.
It was sworn out again.
The challenge is you all didn't take that up on appeal or anything. It was ruled upon by Judge Newkirk.
Your Honor.
So at this point in time, is it fair to Mr. Williams for you to have another bite at the apple? I mean, at this point, because you're asking me to go ahead and let you use this particular evidence that arguably another one of my judicial colleagues has said, hey, despite the fact that we disagree about how the motion has been styled, clearly it would be subject to being suppressed.
And Your Honor.
And even if I agree with you, okay, let's say you corrected all that. 17,530 is still fatal to you. You still would have needed to return the property, and you haven't given me any legal justification for you to keep that property and continue to then investigate that property or search that property. Unlike trial evidence that clear you could have done that. 17,530 is distinguishable because it's like the legislature seemed to indicate, well, we don't want the state to go ahead and continue to keep investigating an individual based on evidence that a court has suppressed. So that's kind of where I am.
Your Honor, if I may, the distinction is that there was a good faith basis for obtaining the search warrant and for getting the search warrant. A search warrant affidavit for the home itself was sworn out. There was, in fact, an arrest warrant that did exist. It was lawful. The fact that there was not one presented in the 16 SC case is what, yes, caused Judge Newkirk to suppress the evidence as to that case, Your Honor.
Okay, and why didn't you return the other stuff to Mr. Williams? You wouldn't have to return the contraband. Everybody's clear about that. Contraband or weapons would not have been returnable to Mr. Williams. Why didn't you return the other stuff?
We had actually sought the search warrant, Your Honor, and I think that the court can look at the dates on the search warrant, on the arrest warrants, and see that we had actually already received lawful authority to search. We had already sought and obtained a search warrant for the items. We had already obtained what the state believed was lawful authority.
If Judge Newkirk has already suppressed the marijuana under the same analysis, okay, then why wouldn't the rest of the stuff that you took be suppressible at that point in time and fruit of the poisonous tree?
Your Honor, the ruling by Judge Newkirk came after the state sought permission to search the items. So we had what we believed to be lawful authority to search the items, the search warrants that were obtained, and we have witnesses that will testify.
Assume I believe you, okay? Assume I believe you.
Yes, Your Honor.
All right. Still, Judge Newkirk grants the motion to suppress. The case is over. You can't proceed on the 16 SC case anymore. The evidence that you all took, why didn't you return it?
Because, Your Honor, at that point, we have, from sources, we have probable cause to believe that within items located within Mr. Williams' home, and this is separate and apart from the fact that he possessed marijuana, but at this point, we have information independent of that to believe that within his home, we would find evidence of these other crimes that we were at that point investigating. Prior to Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even if the court were to see it as more expansive than the state believes that it is, we had probable cause based on information and sources independent of the fact that the defendant had marijuana or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change the fact that the arrest warrant that was in existence at the time actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or Mr. Bailey represented you all on the 3rd of April of 2017, that was, you didn't have that particular certified copy of the arrest warrant And so Mr. Steele, by argument, says, hey, look, I am extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't, that, you know, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, you know, which I have, I've admitted, you know, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April 2017, that's exactly what he was doing, okay? So you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
Your Honor, but the court did not rule that the state had to return that evidence, number one. There was no ruling as to that. I
disagree. I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, you know, I mean, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property that, and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
Okay. All right. All right, let me finish what I was going to say, okay? For purposes of Mr. Steele, you can prepare an order, okay? Sufficient to recap what the court has indicated during this particular motion. Now, I know that puts us in a position where some stuff that you may have the state was going to admit or utilize. Does that change your position, ladies and sir, about where you are with what would be admissible in this particular prosecution?
Your Honor, there are items that, of course, are affected by the courts suppressing the evidence that was seized back in 2015. There are some items that we believe may have more evidentiary value than others. And so it does affect the evidence that the state intended to introduce in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be not admissible at this point in time, given my ruling.
All right, y'all. I don't know why they muted it. Maybe this bitch probably unplugged the mute button or whatever on the camera. Look like the judge is turning to this woman. They done ran into thugger shit, stole all this shit, and she don't even want to return it. A judge already ruled that the weed should be suppressed, and in that suppression hearing, she think that the other stuff shouldn't be suppressed. That's what a suppression hearing is. If you ran a nigga house and took his weed, and you took a gun and some more stuff, the gun need to be returned, just like anything else need to be returned. Yeah, Thugger finna win this one, but the volume is off. That's not us. Let's wait on the volume to come back on. I hate that it's quiet, but we got Justice. We got Kevin, Julian. What you want to add to this, Kevin, Julian, man? They done took the volume from us, man. What you want to add to this before we get back to the show? Wow. Did you see him? He don't want to add. Now, he looked like the judge, though. He looked a little bit like the judge. All right, so look, I guess we ain't got no volume, y'all. I'm finna go back on mute.
Shit, at the end of the day, the law is the law, man. She trying to get around it as the best as possible, but shit, ain't none of them write the law. Shit, she trying to, law is the law, man. Get that man his stuff and let that man out.
It's sad to see her trying to fight to keep his stuff, knowing that they legally took it just because they have some little weak ass investigation. Now that's let me know that everything, the whole investigation gonna fall. Whoever that they found in his phone, whatever they found, it's all gonna fall once the judge said you got to get that shit back. I'm talking about they may have 20 different investigations coming out of his phone alone on 20 different people. Those investigations are gonna come to a halt because you got to give him his shit back, bitch. Y'all should have took out the time to go get a search warrant instead of being all itchy. Let's go get Young Thugger right now before you go back on tour. Let's go get him before you go back on tour. And didn't even get a search warrant. Dumbasses.
How much y'all want to bet the first song he plays when it all falls down? Eureka! Oh, 50. He gonna play that's the first song when he beat out. He actually gonna do a remix to it.
We on the air, got them vocals in the house. Yeah, the volume about to come back in, gang. Here we go. The judge about to rule it. About to come back in.
Trial, those records were obtained through an order from Superior Court at the request of the former district attorney. They contended that the seizure of their records without probable cause was a violation of their Fourth Amendment rights and that the records should have been suppressed. The court in Kessler found that like bank records, telephone pole, and building records are not owned or possessed by the defendant, but are business records belonging to the telephone company. The court further stated that the cases cited by the defendant, United States versus Baxter, Katz versus the United States, recognize the right of privacy in the toll and billing records of the telephone company. The court went on to say that neither defendant, as one user of the telephone, nor the other defendant, as its lessee, had standing to object to the production of these records by the telephone company. Further, Your Honor, Regis, R-E-G-I-S-T-E.
One more time, R-E-G what?
I-S-T-E.
Okay.
Versus the state. And that is 292, Georgia 154. It's a 2012 case that is directly on point with what we have at hand. As an initial matter, telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation of privacy in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 469. Accordingly, the court held that the appellant was not entitled to challenge the release of phone records in this case on Fourth Amendment grounds. Your Honor, the issue of standing has to be addressed before the court begins to even look at any substantive matters in this case. And given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation, he has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in.
She doing all this extra ass talking because they didn't have a search warrant. This is a fucking shame, gang. What she trying to do, rock the judge to sleep? You didn't have a search warrant. You stole the man's shit, give it back. Fuck Hertz. Fuck all that other shit you got going on, man. She tripping. That make a black bitch look stupid in court. This bitch went to college to make us think that she's stupid. You didn't have a search warrant. Stop talking, bitch.
To which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So
black women are always trying to change a black man's mind. They get on my nerve. A black woman is always trying to change your mind. She gonna rock the judge to sleep. She gonna change his mind. Why don't you go suck his dick? All right? How about you go up there and suck the judge's dick? I bet you that nigga will rule in your favor then. Go suck his dick, all right? Because what everything you saying don't make no sense. You didn't have a search warrant. Black women get on my nerve. Y'all always try to talk a nigga to doing something. Suck his dick. What the fuck are you doing? Golly. Go play with his balls or something. Shit. That nigga is not, he done already made up his mind, man. You didn't have a search warrant. Now you have to go suck his dick. All right? If you don't suck the judge's dick, you will not get this one. Okay? Let's get back to it, gang. You gotta go suck his dick.
Still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in, even if it was unlawfully turned over. He cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. He is.
Yeah, it looks like from Kessler that he has a reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. So is that kind of sum and substance what your argument is, madam?
Yes, as an initial matter, yes. Okay. And I mean, we will ask the court rule on his lack of standing before we do anything else related to it. Thank you, Judge.
Okay. All right, Mr. Steele, what say you about standing? It looks like that these are the Hertz records, correct?
Yeah, they're included, that's true.
Okay, is that what you are, as an initial matter, I would agree with Ms. Lovely, your client does have to have standing. I would agree, I would also tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
Okay. Well, and when the Honorable Court started to get into this motion, the court actually asked about Mr. Williams' motion to dismiss the indictment and or a motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote a supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress number 3.
Well, I need to deal with the issue of phone records again. That's what you asked me to do.
The Hertz records.
The Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things, but let's deal with that first. Client's got to have standing in order to address that particular issue.
So I raised it twofold. I raised the motion to dismiss the indictment based upon prosecutorial misconduct. Records of another company, although we want to assert standing, Maddox and the DDOX versus state says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court, like I'm obligated to do, of the case law, and Maddox is.
So you would agree the state's proposition is correct?
I would agree that.
But you disagree because you represent Mr. Williams. Am I correctly summarize that, sir?
Well, it's not like because I represent this. I think the law is inaccurate, but the way I understand the law today, we have to follow MADDOX versus state 346 Georgia Appeal 674 2018. It's exactly correct what Ms. Love said, that there's no standing in records of a corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it. And that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason...
If I may, and I do apologize to Mr. Steele, but I hear him going into the substance of a thing that necessarily relies upon his right to complain about the state's method of obtaining the records from hers. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the Hertz records.
Understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkle, if you allow me to briefly proffer.
Okay, you're going to proffer as to why you need to call Mr. Sprinkle.
Yes, because I think that's where it starts. So, what happens, Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to the Honorable Court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know, Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to Cellbrite without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbrite, I would introduce through Mr. Sprinkle, says, as a courtesy of the District Attorney's Office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case, and it's not only hers. It is every grand jury subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably, Mr. Sprinkle is on every one of these, he has a district attorney's seal on the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkle sends all of these subpoenas outside the state of Georgia. There's no authority for
indicate which subpoenas he is referring to when he says all are, because the only one that I'm aware of that he has referenced is the Hertz subpoena to Florida. But as a matter of fact, I will just let him continue, and I will not.
Yeah, he's proffering as to why.
Oh, he is. He is.
What's up, gang? Look like they got us back on mute, man. But look, we digging into it. That black bitch needs to sit her ass down. She keeps fucking it up for the prosecution. I'm gonna tell you something right now. If the prosecution was to even have an inch of winning this particular hearing, the black bitch just fucked it up. All right, sit your black ass down. You know what I'm talking about? Somebody stick something in that bitch mouth because my zipper is stuck. Y'all know Robin Harris said that shit in 1989. Stick something in that bitch mouth because my zipper stuck. All right, check it out again. They took the volume back off. Don't worry, the volume be back up. It seemed like they tired of hearing this black bitch like we is. Prosecution look like they lost this one. I'm gonna let y'all get a conversation going real quick. Kimberly, look like you want to say something. You got the flow. What's going on, gang? Look like Thugger finna go home.
Shit, I agree, my brother. I think everything points to the prosecution don't fucked up everything, man. They don't really have anything to stand on to show that they had probable cause to search that man's stuff, man. All they had was the weed.
They always do this. They always go to your house, steal your shit, pick you up, throw you in jail, and then they act like this ain't gonna happen in court. This happens all the time in court. If you don't catch the technicality, you go to jail for the rest of your life. If you catch this small technicality, you go home, bro. This happens to a lot of cases. This shit is crazy.
Dude, I just came
She
home.
forgot she was dealing with a whole high-profile rapper.
This is high profile. This ain't a little bit. I picked the nigga up and throw him in jail. Now, this is a good attorney. Ma'am, you're fucked. Okay? You're fucked. A search, everything you did after the search warrant is void. You can't use nothing because you didn't have a search warrant. You can't use nothing afterwards. It's void. I don't give a fuck. You want to keep his laptop. You want to keep his fucking Sega Genesis. You can't keep shit, bitch. Give him all this shit back. I'm tired of this shit. And she ain't got no argument, Kimberly. She's trying to make it like she got an argument.
So,
she has no argument.
Ms. Doug's argument is, and the court's inquiry of you is, what reasonable expectation of privacy do you have, or standing do you have in these records?
This is not the issue. This issue goes to dismissal of indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the district attorney's office.
So you're saying you'd like to examine Mr. Sprinkle for his motives, or for as to why he sought these particular documents in this prosecution?
I want to subpoena, well, I have subpoena. I want to call Deputy District Attorney Mr. Sprinkle, because I want to ask him why he believes he had any right, which I'm contending violates Mr. Williams' rights to due process as stated in State versus Lampel, L-A-M-P-L, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and or motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or account thereof. However, it is a remedy. It's a due process violation. When the state's talking about standing, you can't have more standing than all of these people here who are indicted, wrongly indicted based upon the misconduct of the district attorney's office. And we don't have to sit here and allow the district attorney's office to violate the law and just put us in indictment without this honorable court hearing it. And if this honorable court finds that it reaches the level of outrageous prosecutorial misconduct by the systematic abuse of process by our district attorney's office, then the indictment is dismissed. The state is arguing something that has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights, because everyone here, I assume, joined the motion. Everyone here is suffering from the state of Georgia's unlawful abuse of their power.
What's
That's the
Lampel's
issue.
site again?
Mr. Lampel's site is .296 Georgia, 892 Division 2, 770 Southeast 2D, 629, 2015. I had the honor of representing Mr. Lampel. On that case, it went to Court of Appeals of Georgia, then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Mara. Mr. Lampel's the mayor of Mara. And that's why I would like to call Mr. Sprinkle, because he's sending out, under the auspices of a grand jury subpoena, with the district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider and Mr. Sprinkle would be asked. There's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which we already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is, why would the subpoenas go outside of the state of Georgia? The fourth one is, why wouldn't you return the property? And the fifth one is, why would you bring a human being before a grand jury when you don't have a real bill of indictment, and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
Okay.
Your Honor, the defendant still has not addressed the issue of standing as to any of the...
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been aggrieved. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test, and he's also saying, hey, he's an aggrieved person because he's under indictment for these particular charges.
And Your Honor, if I may, I don't know why Mr. Steele cited Lample in his brief, because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the court's
It seems like every time she started talking, they go on mute, man. Every time this bitch started talking, they go on mute. All right? They tired of this bitch. They know she done lost her case. She's trying to beat a dead horse.
Supreme
No
Court.
search warrant, no
They've been
probable cause,
indicted. And when the Georgia Supreme Court says, no, you lack standing,
and they're gonna say,
being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they could simply give us the documents we requested them. They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of the argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pot. But, Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
All right, well, just give me a second, please.
All right, gang. So it looked like the judge went to go take another shit. I mean, talking to that bitch, I have to go take me another shit too. Ain't no way in hell I can sit up and let this bitch talk to me in court the way this bitch talking without me having to take a shit. This bitch just don't get it. She don't understand, ma'am. Y'all crooked as fuck. Y'all walked in Thugger's house with no warrant. Every last one of you motherfuckers should be thrown off of a bridge, okay? If somebody walked in your house, man, with no warrant and took your only wig, your ass would be in court acting crazy. So why are you trying to defend the fact? Because they have no case. Guess what? Somebody just said this in the crowd, gang. If they don't have no case, that means no RICO case. Am I right, gang?
Looking
Come
like
off of
London
mute,
Bridge
gang.
is
Let's talk.
falling down. It's looking like
Everything gonna
London
fall
Bridge is
down with
falling
this
down.
one. And that means that Gunna snitched for no reason, because if they find out that that motherfucking That search warrant, which is no search warrant that they can't even find. They gave him a late one, tried to stick it in. He said, how you gonna send me one now? That means no RICO. That means Gunner, you on probation for 5 years and you didn't even have a search warrant, Gunner. Gunner, you dummy. Let's talk, gang. How the fuck you think on probation for 5 years they didn't even have a search warrant? Let's go.
I think, you know what, I'm starting to think about that Gunner situation. I think they knew this was coming down, the prosecution, so they really squeezed Gunner and put Gunner in this situation. Because I think what they're gonna try to do is flip the script and use Gunner, because you know Gunner signed those papers, so he got to give us information probably. So if this don't work, Gunner, they fail safe. That's fucked up.
Nigga, you ain't, bro. Do you know how mad the prosecution was when my attorney said that y'all couldn't even prove that he ran the stop sign? And the judge say, I'm giving you an opportunity to prove that he ran the stop sign. If you can't prove he ran the stop sign, that means that gun, everything y'all took out of his car, everything go back to him, is over. And they was just like this woman. They was fighting. But wait a minute, though. We was in a different cruiser. I don't give a fuck, bitch. Every cruiser got a 30-second delay. Can you prove that he ran the stop sign? And eventually, after 2 hours, they couldn't prove it. The judge threw that bitch out. I'm telling you, gang, this nigga finna win, y'all. I'm being real. It don't like gonna be no fucking RICO either. What you think about this Rebel Pac, man? You got your volume going yet? Rebel Pac, what's up? You got your volume? No volume? All right, cool. Don't worry about it, Rebel Pac. We know you see this bullshit on the screen. You know what I'm talking about? Now, black women, you know I love y'all. Matter of fact, I got a female. Hold on one second, y'all. All right, shout out to the game, man. All right, so yeah, I was just because I'm right now. I have a female in here with me now. We definitely doing our thing. She helping us out in the studio. Just tell because we right now. Just let them know we definitely doing our thing. Tell them hi and tell them where you from and this and that. Because right now we are in Austin, Texas, but she's not from this country or any other country. Let them know where you from.
Hi y'all, I'm from Nepal. Namaste guys. This is Ashna. Really nice to meet y'all.
Speak some Indian. Let them know. Let's speak some.
Okay, Nepali. Mero naam Ashna ho. That means I am Ashna. That's what I said. And namaste means how you say hello in Nepali language.
Already, so y'all just learned
Let me find out paperwork smuggling humans.
Look, I ain't smuggling on you. Look, y'all just I already appreciate that. That's my girl, man. Hey, look, let me tell y'all something. You gotta do both. Hold on 1 second, y'all. Now, what I'm saying is this. Ain't nobody smuggling on humans. All I'm saying is this. Let me set the volume back on. Hold on, guys. All right. Look like the volume's gonna come back on here in a minute. But look, all I'm saying is this. Look, y'all, this woman is making all black women look bad on the damn screen. Okay? No means no. All right? If you want green beans, mashed potatoes, and all that other shit, that's good. But when I say you can't get seconds, that's no. No means no. She not taking no for answer. The judge is gonna take a second shit because she's still up talking. What's going on, man? What's going on, Kimberly? Why don't this woman know no is no? Paperwork of passport, bro. Shout out to Rob, man. Man, look. The majority of people around me are foreigners, but at the same time, I love my black women. I just want y'all to know y'all can't be in court talking like this, all right? She's still talking, and the judge ain't even up there. What's up with this bitch? The judge is he up there, y'all?
Yeah.
Is that him? Hold on. That is him. Oh, they took the volume off. Yeah, he up there, y'all. They just took the volume off this bitch. They tired of this bitch. Let me check my other channel too, make sure. Yeah, the volume is off. All right, y'all. Court is back in session. The volume is off. Let me answer my cell phone real quick. Let's get back to it, gang.
So tan, gorgeous. You have beautiful eyes. He also he's like, you must work out. And I was like, yeah, I do. You know, and so we just started getting it. Sign into Y906.
You know why she ain't a quitter? Because this one hearing can determine the whole fucking case for the RICO. That's why she gonna talk that nigga till she crawl up there and suck his dick. She's literally gonna have to crawl on all fours, y'all, to get this one. All right? She gonna have to crawl on all fours. That nigga up there wants some head. He ain't trying to hurt shit as you saying, ma'am. Now he want his
I'm gonna
dick
go by the
sucked.
store and
Right?
drop this one.
Hey, he ain't trying to hear shit else. He want his dick sucked now. You done talk too much. No, I know all black women are not the same. I know that. But this black woman, she act like she represent all black women, all right? We love you, Denise. All black women are not the same. My mom is a black woman. I love black women, okay? I happen to have a black woman as a mom. But guess what? This bitch right here, before you know it, mark my words, she gonna be crawling up on all fours, all right? And she gonna have to suck that nigga dick to get this hearing, because look like Thugger won this one. They need to cut the volume back on, man. I'm tired of this. There we go. Look, they doing it on purpose. They cut the volume off on her on purpose, y'all. They tired of hearing that bitch. They know she lost the case for the prosecution. Thugger, it ain't gonna be no
Mr.
RICO,
Bailey,
y'all.
I mean, not Mr. Bailey, but Mr. Sprinkle.
Let's go.
You're challenging by way of the evidence that you were presenting, or that I said you didn't have any standing to see what Mr. Sprinkle, in fact, did present to that grand jury and what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Was it discovery?
Yes. Okay. Will not ask anything about what occurred in a grand jury except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion to suppress? Yeah, that's what the motion was. I ruled upon the issue of the all right, I think I'm back on at this point in time. In terms of the motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that of the relevancy of these particular records, but also they're protected by work product under 24-5-501. And for those reasons, I'm going to deny it. I'm going to grant the state's motion to quash on those two subpoenas. All right, anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has voted to suppress statements on the record. We have a witness here, I've spoken to counsel. He doesn't intend to go forward on that motion.
He does not intend?
We were hoping we could release our witness. Who's in here, but...
Yes. Any objection, counsels?
No, just to be clear, we're not withdrawing the motion. We would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein, W-E-I-N-S-T-E-I-N.
Mr. Weinstein, what's your client's name again?
Giovanni Kendrick.
Sorry, Your Honor, we're just hoping our witness might be able to go.
Well, you know, folks, I like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court. So, what is your motion? Your motion is to suppress?
Yes, Your Honor.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, I believe he doesn't want it heard today, and we don't object to a continuance. So
Oh, okay, all right, so your motion is suppressed, all right, we're gonna, okay, all right, I understand.
Thank you, Your Honor.
I'm with you, okay, yes. All right.
Your Honor.
You give a mouse a cookie, what is it you want, Mr. Sharp?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the motion.
It's not your turn yet.
Well,
You jumping in front of Mr. Steele now?
No, I am not jumping in front of him.
Okay, all right. What is it you'd like to tell me?
Well, I filed the exact same motion that Mr. Steele filed.
And your client is, sir?
Stillwell.
Mr. Stillwell, okay.
And that was filed on November 16th. And
the motion to dismiss the indictment?
Motion to dismiss the indictment.
And motion to suppress evidence. You wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather the prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by illegally issued subpoenas.
I'm going to deny the motion to dismiss the indictment, okay?
Okay, well, I just wanted to make sure it was on the record that I, too, have filed that motion and I want to put that on the record.
Okay. All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Actually, Judge, just while we're here for the record.
Yes, Mr. Menaez.
I have failed to adopt the motion as ready, but I did want to respect the record that that's on me, and that was effective, but I do want to orally also adopt Mr. Steele and Mr. Schultz's
All right. Well, you probably should reduce that to writing, but Ms. Rosen wants her, if you will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm going to, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
I'm sorry, would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite the same cases and,
Yes.
thank you.
So we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? I was going to ask you to complete that issue of the proffer, and then also if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proffer.
Ms. Rosenwasser, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Someone after you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Someone.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can at this point.
Where's Mr. Blaylock's attorney?
It's me, Attorney Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay. And you were counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, can you say that one time?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Blaylock, okay, all right.
Demond Blaylock, yes.
All right, Mr. Rosenwasser, do you have a copy of the proffer? Could you please, ma'am? I don't think I have it last year. Huh? Oh. Yeah.
Hold on, is that the snitch right there, gang? Is that the snitch? Oh my God, Jesus Christ. Lord, what the fuck is he about to say? Oh, Jesus, this is bad, y'all. Is that the snitch? Hold on, which one of these is the snitch? They're gonna try to go on mute when they start showing the snitches. Who is about to test? Uh-oh, here go the volume, gang. We about to get the volume back. Who is the snitch? Wow. This about to be good. This finna turn to a rat infested damn.
We kind of
hold on, y'all.
jumped the gun a little bit, just to so that myself and Ms. Weaver are in sync as to who is present today and who's representing whom. Can we just take roll call as to who's here? So we'll start out with my left, your right, gentlemen or ladies. If you're representing anybody, could you kind of state who you are representing, please?
For the safety.
Okay, all right.
Adrian Brown for the state lawyer.
All right. Okay. That was really.
Adrian Love for the state, Your Honor,
Okay.
Deputy District Attorney.
Yes, ma'am.
John Floyd for the state.
Deputy District Attorney Simone Hilton for the state. Assistant District Attorney Lizzie Rosenwasser for the state.
Okay, all right. Now for the defense counsels and their clients. All right, we'll start off, Madam, I forget, and on the right side.
Chelsea Golden from Miles Farley.
Thank you, Madam.
Anastasio Spinetis for Mr. Miles Farley.
David Bob, Shannon Stiller. Max Shard for Shannon Stiller. Keith Evans, Jeffrey Williams.
Your Honor, Brian Steele, I'm also representing.
Okay. All right. Counsels in the back, anybody representing anybody here today? Madam? In the orange?
I'm sorry.
Yeah. I'm sorry, one more time?
Nicole Morgan for Companies Group.
Yes, ma'am.
Dana Bernard for David Myrick.
Michael Russ for Mr. Beer as well. Good afternoon, Suli Shout on behalf of Mr. Dorsey.
All right, continue to the center.
Doug Weinstein for Mr. Diamante Kendrick.
All right. Hold on, Mr. Harvey, I think it's you.
With Mr. Nelson, along with Nicole Westmoreland, she is on Zoom, and you can see that she is on Zoom as well.
Yes, sir, thank you. All right.
Angela Williams for Mr. Ryan.
Thank you, madam.
Sean Hoover for Antonio Sutton.
Okay.
Justin Hill for Demond Blaylock.
All right. Continue, madam.
Christy Gladden for Trontavia Stevens.
Thank you, madam. All right, anybody else to my left, your right? Okay, all right. Just want to make sure who was here along with clients today. All right, okay. Thank you very much, counsel.
My name, I apologize. I'm here on the platform, Tiambre Callan, on behalf of Mr. Khalif Adams.
Okay. All right, anybody else on our Zoom platform? I'm sorry that we had such difficulty with today. Anybody else? Is your client, Mr. Adams, on the platform as well?
He is not that I see, Your Honor.
Okay.
He's in the back row.
He's in the what?
He's in the back row.
He's here actually in court. He's in the gallery, madam.
Thank you, Your Honor.
Okay, all right. One more time, counsel, your name. I apologize, madam.
Tiambre Callan.
Well, and can you spell that for us, please?
Sure. First name is Tiambre, that's Teombre. Last name is Calland, Calland.
Okay. All right. Okay. All right. All right. So we're talking about profit. So, Ms. Rosenwasser, do you have that?
Yes, Your Honor, I was able to locate a transcript from a previous hearing.
Okay, all right. So can we take care of Mr. Blaylock's proffer at this point in time?
Yes, Your Honor.
All right, let me go ahead. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand, please, sir? The best you able. Do you solemnly swear or affirm the evidence you'll give in the matter now hearing should be the truth, whole truth, nothing but the truth, so help you God so affirm?
Yes, sir.
All right, you put your hand down. Sir, we're just gonna ask you a series of questions just related to the proffer, nothing else. And then after that's done, I'll make a decision as to you and your counsel, okay? All right, Ms. Rosenwasser, if you go ahead and read that particular cover. He's already been sworn, so.
Sir, I recognize you're currently being represented by, I'm sorry, your name, sir?
Justin Hill.
By Mr. Justin Hill, is that correct? And sir, were you previously represented by Mr. Sean Hoover? Are you aware that Mr. Hoover is still representing your co-defendant, Mr. Antonio Sumlin? Okay. Now, have you been advised of a potential conflict between this attorney still representing Mr. Sumlin? No one has advised you of a potential conflict?
Oh, yeah.
So, yes, someone has spoken to you? Okay. Is that your attorney right now who's spoken to you about that? Okay. Who spoke with you about that? Okay. Did a woman, Ms. Rivera, speak with you? I'm sorry, sir. I'm being confusing. Has another attorney, anyone other than these two guys, ever come and talk to you about this case?
Hey, gang, they fucking up that on purpose so we can't hear the snitch talk. That's the weakest shit I ever seen in my life. They don't want us to hear the snitch, the little rat talking. So since we can't hear the rat talking, they fucking up the volume on purpose. So that's not me, that's the volume.
Okay. Are you aware of, so you are aware of that conflict? Okay. You understand that you have had, even if you have had meetings with this counsel, Mr. Hoover, you still have no objection to him continuing to represent your issues, so including that anything that this council has learned from you could be used in your code of ethics defense. You don't waive that? I'll try again. Do you understand that if you went to trial, anything that he learned when he was representing you, Mr. Hoover, could be used to help your code of ethics yourself? Okay. Do you still waive any conflicts? Okay. Your Honor, I believe that confirms any conflict.
Mr. Blaylock, did you, before signing that, have the opportunity to talk to counsel to your satisfaction? Yes? Okay. And you give this waiver freely and voluntarily, it's your own decision to waive any potential conflict in this case? Yes. All right. Are there any other questions about this particular conflict you want to ask me? Okay, all right. I'm going to go ahead and Mr.
I believe that covers all the waivers.
All right, look like they done cut the volume off again. Maybe that snitch is talking. Look like they done cut it off again, man. All right, gang, y'all can come off mute me real quick. What y'all want to discuss on this? Look like we three, almost 4 hours in, man. It's going down. Like they really don't want us to hear the snitch. What if the snitch is what if it's Gunna over there talking, y'all? What if that's Gunna? They done blocked out Gunna. Like Gunna, man, y'all better play with the wires, man. I want them nigga hear my voice. They don't put me on camera, nigga. Somebody over there snitching shit. Who the fuck is snitching? Killer, man, where are you at? Come off of mute. Shout out to Killer, man. We on your ass. Come off of mute. Kimberly, what's up, Kimberly? Oh, here it go, y'all. Here it go. We need to hear the snitch. Bring us the voice of the snitch.
This the worst movie ever right here.
Your Honor, at one point he had an attorney. I'm not sure if that attorney was withdrawn. It was for Larry Hemingway. So I don't know if she is for Larry Hemingway. I don't know if she's withdrawn. I know he had an attorney when I was doing a lot of motion service last month.
From my understanding, Ms. Hemingway still represents Mr. Fleetwood. I'll definitely double check.
I'm sorry.
She does not. She works in the same office.
Yeah, I think that was the problem.
I'm not sure if she's formally withdrawn though yet, so that may be why this has arisen.
So, Ms. Bernard, can we do just a housekeeping matter? Can you ask her to formally, she's not done so, withdraw? And I will ask Mr. Hoover to go ahead and continue that process of representation, okay?
Yes, sir.
Thank you, ma'am. All right, so Mr. Hoover, you'll take care of that and we'll do this?
Yes, Your Honor.
Okay, all right. Mr. Arnold. Where are you, Mr. Arnold? Oh, good afternoon, sir. Who's your attorney?
Ashley Murphy.
Ashley Merchant. Okay, all right. All right, sir. We're going to go ahead and I believe that she's had something else to do this afternoon, but we've been in touch with her, okay? So just give me a second. All right, Mr. Beebe?
He's still the call center.
Is he on the...
No, he's not on the platform.
Who is his lawyer?
Mr. Partridge has to go to Upson County for another trial today.
Okay, all right. All right, Mr. Eppinger. Mr. Eppinger, you ready to have it? Who is it?
He's right here. Right here.
Oh, thank you, sir. I apologize. Okay, Mr. Eppinger, who do you represent by, sir?
Eric Johnson.
Eric Johnson.
There was no communication.
Okay, all right. All right.
And, Your Honor, I have my office reach out to Mr. Johnson, so we will make sure it will be.
Thank you, sir. Appreciate it. All right, and Mr. McMullen. Mr. McMullen.
I believe
Who? I'm sorry?
Amanda Young. I believe there may be conflict.
She withdrew, and Attorney W.B. Green will be representing her moving forward.
Very confidential.
I want to say yes, but I have not double checked myself.
Who is Mr. McMullen's attorney now?
W.B. Green.
Do we have a withdrawal? Who is his prior counsel?
Amanda Young.
Amanda Young?
Yes.
Do we have a withdrawal from her as of yet?
Yes, the court did.
Okay, all right. Do we have an entry with Mr. Green?
We do not.
Mr. Hoover?
I'll make sure it gets done, Your Honor.
Okay, he needs to do it. Four on that. It looks like Mr. Green entered an appearance on four on that.
Okay, perfect.
Okay, all right. Mr. McMullen, I'm going to go ahead and since your counsel's not here, we do have some, he'll talk with you, but I'm going to release you at this point in time, okay? Mr. Eppinger. Mr. Eppinger, I'll release you at this point in time as well, since your lawyer is not here, Mr. Johnson's not here as well. Mr. Beebe, where are you?
Not here. He's not here.
No, Mr. Beebe's not here. Okay, all right. That's fine. Thank you. All right.
Order in the court, please.
Mr. Arnold, I'm going to release you to Mr. Ginsburg, and then come back and talk to you, okay? Mr. Fleetwood, where are you?
Yes, sir.
Yes.
I'm trying to see why they trying to have a lawyer represent me at the last moment. I've been in prison.
You are, I'm sorry, one more time, you are, sir.
I'm trying to figure out why I got an
You are,
attorney
sir.
trying to represent. I'm trying to see why they got an attorney trying to represent me at the last moment. I ain't Fleetwood.
Mr. Fleetwood.
I've been in prison for 5 years. I ain't getting no chance to talk to no lady. Nobody. I've been on 24-hour lockdown, sir.
Mr. Fleetwood, I believe that you raised that concern the last time that we talked, and you were on Zoom, and that is an issue that you can take up with the lawyer that actually gets appointed to represent you. So, I understand, but that lawyer is going to talk with you about any issues you may have in regards to representation. It's not today. Mr. Hoover, when do you think we can get him appointed counsel? Because he's very anxious to talk to the lawyer.
I'm working on it right now, Your Honor. See.
Okay, so Mr. Fleetwood, they're going to go ahead and get you counsel, okay?
I think this young man is saying that he wants to get his own lawyer.
Well, if that's the case, then you certainly is welcome to do so, Mr. Harvey.
Well, I just wanted to.
I understand. And you're welcome to use your own attorney, but this case was indicted back in May of this year.
I've been on the till 24 hours a day, not able to contact my family at all, sir. Every time.
I can't hear nothing but hit the like button, share the live. Did he say 24 hours? He can't even contact his family?
All right, Mr. Darlington? Sir, I'm going to go ahead and you're going to get another lawyer, Mr. Darlington, right? So you're going to get another lawyer. That lawyer will be in touch with you soon, okay? Because Mr. Lewis withdrew, but we'll make sure you get, Mr. Hoover's going to make sure we get your lawyer appointed, and that person will come and talk to you soon, okay? Okay, you can be released at this point in time. Yes, ma'am. Where's the chief? That's fine. All right, Mr. Mender? Yes, sir. Mr. Mender, we're going to return you to the state and talk with you soon, okay? All right, thank you, sir. And Mr. Sledge? Yes. Mr. Wright was on a little earlier. I'm going to return you as well. He was on the platform, but we've had some issues with Zoom today, so I'm going to talk with you otherwise. We'll see you soon, okay? Yes. All right, so I'll release you this time. I'm going to follow forward. Are there any counsel in here who have motions that have filed, but you are having discussions with the state, you don't want to have the motions for today, you just table them? You know, go ahead and just let me know. anyone?
I don't know whether it's possible for me to do all my motions today. I'm not necessarily with the state because I'm in a trial group. I would like the opportunity to talk to someone before we proceed with my evidentiary motions. That's on behalf of Mr. Nichols.
Oh, I see. Okay, I see. Ladies and sir, is that something you all would like to do something?
Yes, Your Honor. We can always, yes.
Okay, Ms. Harvey, that answer your inquiry?
Yes, thank you, Judge.
Okay,
I'm just here to get my COEs from Mr. Voss and Mr. Steele.
Your Honor, that's not true. He's old enough to where he don't need COE.
That's true. That's true. So is David. So is David.
The hell so funny?
You hit 105, you don't need.
Well, I heard you were saying that over 70 was good, so yeah. Is that easy? All right, okay. I'll track that. Okay, is there anybody else? Okay, you know what, not told me you'd like to go ahead and entertain your motion.
Well, Your Honor, I have a different issue. I was just retained and just filed my entry, so I do not believe that I have any motions pending, but I'm not sure if there were any that were unheard by previous counsel.
Okay, who do you represent?
Trontavia Stevens, Your Honor. Mr. Flugel had to withdraw because his wife had a medical issue.
Yes, and we are familiar with that issue.
Yes, Judge.
I would like to, he has several motions, ladies and sir, if he ever rule on any motions, I know that he argues some.
Your Honor, some of the motions were ruled on. I think particularly with all the demurs that Mr. Floyd handled last time.
Yeah, Ms. Glenn, I've got a couple of them. He's got a motion to testimony to tax.
I'm sorry, Judge, maybe not hearing it.
One more. You on the record.
Thank you, Judge.
There is a motion to limit the testimony to facts stipulated in the plea colloquy. I don't believe we've taken that up or taken that issue. I know that we ruled upon the special demurs as to count 1, acts 48, 49, 50, 52, 53, and 54. And the special demurs to count 1, acts 127 and 132. Mr. Floyd, did we take up anything else in regards to as it relates to Mr. Stevens? I believe that you argued and I ruled upon those particular motions the last time we were here, sir. Is that correct?
The ones that you just described, Judge, yes, you did rule on, you denied them.
Oh shit, back to the secrecy.
Go on and spark it up, Killer Cam, man. Go on and start a conversation, man.
Okay, so this is the thing though. I'm having an issue. For one, what the fuck was so funny? What was they talking about? Because dude, last thing I heard from dude is he was begging for some free time because he's on damn near 23-1 and can't talk to his family. This motherfucker's in here crying out for help and for their
Mad
life.
Mobile's cake product suite
And they in
covers
there
every
laughing.
aspect of your business.
Fuck so
From
funny.
reservations, online ordering,
Dry-ass
curbside pickup
court
or
joke.
delivery, to payments and reports. With our Google integration, guests can easily find your restaurant online, make a reservation, or join the waitlist virtually. Reduce walkaways up to 25% by communicating with guests via two-way text, and automatically notifying them when their table is ready. When it's time to order, guests can use kiosks or place their order with a server tableside and have those automatically sent to the kitchen or KDS. By adding kiosks or tableside ordering, check sizes can increase by an average of more than 30%, putting more money in your pocket. Payment is simple and secure using a QR code on a customer's own device or directly with a server tableside. With Mad Mobile's cloud-based
We'll certainly, we will certainly entertain you at some point in time, okay?
Indeed, thank you.
Okay, all right.
Yeah, okay.
Anybody else?
I think I'm on now, baby.
Okay, all right. Ms. Love and Mr. Floyd and Ms. Hilton and Ms. Rosenwasser, and council, all of you, I know that we were supposed to take up the jury questionnaires. I think I'm going to not take up those issues today. I'll wait until probably Monday or Tuesday of next week. Since all the lawyers are not here, most of them will be here probably on Monday or Tuesday, and resolution may affect some of those particular folks. So I will wait on that. I'll table that. I'll hold that for just until such time.
Oh no, this don't sound crazy what he just said though.
How come everybody's lawyer ain't there though? Like, how is your lawyer not
Counsel
coming
for the
to
state,
represent
are
you?
you engaged in any I know that you're supposed to begin your motions for the Daubert and 702 issues effective as of Monday. How is that coming, Ms. Rosenwasser?
So, Your Honor, we have spoken up, we provided on last Friday a list of, everyone we're expecting to call as a expert witness with what we're going to qualify them in. We have provided CVs in a Dropbox folder. I believe, and don't quote me, I think the list is at about 27, 28 people at this point. Some of our witnesses are only available the first week, some are only available the second week. So we would just ask that the court honor that. And additionally, we believe that only one or two witnesses will need testimony via video conference. Only one defendant objected to that, and that defendant is no longer on this case. So we anticipate almost everyone's going to be live.
Okay.
And we may have some amendments, but we will let the court know if there's any additional people we're going to call.
Okay, thank you. And that's a good update. What I was going to just is ask if there are any negotiations or other pleas that may be taken from this particular case that, and I don't know which defendants are interested in that, but that might be something that should be considered and discussed. I'm available tomorrow afternoon, and I was going to see if that could be taken on Monday. For those particular, Monday is the 19th. Since we're going to be here all day, if we could utilize some part of that day, Ms. Rosenwasser, if you would be so kind as to send those who are left an email just outlining which particular witnesses you'd like to call on which days, that would give us some roadmap.
Absolutely, Your Honor. And we don't know how long everyone's going to take. We anticipate some days it may not take a full day, some days it will. We have one witness coming on Monday that can only testify. That's the only day she's available, but I think everyone else. We just ask that some of our people can be if they're close by, could be placed on call.
Sound good.
But other than that, we have everybody here, and we'll send out an order to the court, an order that people will be pending call on which days on Friday. I can do that.
Yeah, and the other thing I was going to just point to everybody's kind of, I know my order says the 19th through the 22nd. I think that we in the county are off on the 23rd. Is that correct?
Yes.
And then we were also off on the 26th.
Yes,
Yeah. So I made a mistake as to that, as to our availability. So just adjust your schedules accordingly.
Yes, sir. Yes, sir.
All right. Okay. All right.
They done took so long, they done lost some of their damn witnesses and shit.
All the musty ass inmates done came through. That bitch smell like a boxing room.
Ooh, so it look like a smell like a sauna sweat.
That court stinks. You know that courtroom stink. You got Young Thug in that bitch musty as fuck. And you know if that nigga was musty, he was in the suit. Think about them other nigga that just dragged in that bitch. That bitch
in
smell
that hot ass suit. Ugh.
I'm talking about it's musty in that motherfucker. But guess what? Let's get back to it.
The judge ain't that shit he white was an
Ever.
What she did was since she didn't have a search warrant, y'all, and they went and thug shit and stole his shit, instead of the judge like ruling on that, it's extended till Monday because she brought all these rats. These prosecutors crooked as fuck. They're gonna try to make him forget about that search warrant. I hope that nigga don't forget about this shit Monday when all these rats start testifying. Because think about it, you put 4 rats on the stand, they all start testifying. You been forgot about the search warrant. You be like, hold on, Thugger did that.
That's what they tried to do last time when other judges dismissed it. They tried to keep it going and hope he forget.
That's what they bro. Look what they doing, y'all. Look at the tactic of the prosecution. The prosecution just got caught going and Thugger shit without a search warrant, and this hearing should be over, right? They prolonging it until Monday because they want the judge to forget about the basis, which is a search warrant, and they got all these damn rats finna start snitching.
And that, if it was a legal search warrant, all that shit is null and void. You can't even use that shit against him.
And see, and here's the whole kicker right here. When they went in the house, they still needed evidence in order to make their case. They didn't just have the evidence and have them. They went in the house. They needed the house, the evidence in the house.
Right.
Judge, I did file a motion to suppress on December 5th.
Are they saying motion to suppress the search warrant, the illegal search warrant, or whatever they found?
I think they had filed a motion to suppress the weed that was found. You see what I'm saying? And when the other judge, when he granted the motion to suppress the weed, then this judge is coming. I mean, this attorney was coming back saying, "Hey, bro, since you suppressed the weed, you should suppress
everything else." Yeah,
all that fell under that. All that was under that marijuana suppression.
Just like when I ran it, when they say I ran that stop sign, which I didn't run the stop sign, what it was, I had cameras around my fucking crib, and you can actually see the police following me. They was parked down the street at somebody else's garage. They followed me from my crib. They lied and said I ran a stop sign and tried to, you know what I'm talking about? So,
I know exactly.
Yeah, I done got set up before, man. I already know how this be set up, but
I would do that same bullshit.
Hell yeah, and they do the same shit. They got the same routines. And in this instance right here, We know it's an illegal search warrant, but they got the right to speak as long as they want to speak, right? So they finna do 3 fucking rats, 3 or 4 rats. That's finna make everybody forget about the search warrant and put this nigga back on the burner. Because they definitely put this bitch back on mute. Like, these motherfuckers. And the funny part about it, like, this judge, he knows a lot. Why is he but he has the
It don't even make sense because
he got
if you win the suppression hearing, you win everything.
Well,
the reason suppression hearing is over.
Yeah, that's what I'm saying. People don't know that about suppression hearings. You're right about that. But one reason that this judge has to entertain what they doing is because he wants to avoid an appeal.
They the state, because they the state and he the state. That's why.
Well, yeah.
Well,
and
let him finish and he'll tell you.
But but they also, when it comes to the appeal part, they can appeal this bitch if he don't let them get their 3 rats in.
That's true.
You see? So they got to put the rats up. They got to do this and that. They got to do all that.
That's true.
And just to make him forget, but then he's not going to forget. But then it's going to be an impact on his decision when these 3 rats come snitching on Gunner. I mean on Thugger. Impact. You know what I'm talking about?
Yep.
So
it made complete sense, and they find in specific times when they want to mute it, and when it's getting to certain things that we may want to hear, they take the sound away. I'm like, how do they know that?
Now hold on, Kyle. You got me fucked up, Kyle. I'll show you the paperwork. I got a dismissal on the suppression hearing. Matter of fact, I got it expunged and all the paperwork is burnt up. But I got
if you get a suppression hearing dismissed, if they're suppressing, he must be talking about if they suppressing just a certain part of the evidence.
Yeah,
we're talking about if they're suppressing all evidence.
What's his name? What's your name?
That's Rebel Pop.
Yeah, Rebel. Yeah, Rebel.
Rebel Pop.
Yep, Rebel.
All right. Rebel,
but look,
nice
watch this.
Nice to meet you too.
He not lying. A suppression hearing. Suppression means to suppress evidence. Judge, this evidence should be in. Let's have a suppression hearing, suppress that evidence because it may impact the case. All right. So one thing about a suppression hearing, if you suppress the right evidence, one time I had a suppression hearing, y'all, and we suppressed the testimony of the officer. Man, it was so funny, y'all. The officer got on the stand and he was lying his ass off, and the judge said, "You know what? Let's suppress this." And once they suppressed his testimony, they had to throw the case out because the whole case was his testimony. You see what I'm saying?
If you see his lawyer, when he first came up there, he had an old case in his hand where he quoted the exact case.
Nah, for real, that's what I'm saying. They got it. That's called precedent.
They have to find a case that's just like your case, and they got dismissed. They got to dismiss your case.
Because another judge, you can't rule and you have to rule in favor of other judges on the same situation. That's why they got cases that's precedent. And since they had read off other cases precedent, that judge got to look at that like, okay, if these other judges ruled in this particular form, we have to rule just like that judge because the case is similar and synonymous.
Exactly.
So yeah, you're right about that.
You're right.
That's exactly what it was, y'all. I'm telling y'all. The only way, and look at this black bitch right here, y'all. And she's pissing me off. The only way, y'all, that this black woman in them is gonna get any leeway is when they throw these 3 rats up. If they say something that's gonna piss the judge off about Thugger, that's it. That's it.
They didn't pull the camera back and everything.
It's kind of already. It's kind of already.
Hold on, Rebel. Now.
Okay, my bad, baby. My bad.
I wonder who they bring into the stand or what they discussing that made them let us see, because there for a minute they kept us all zoomed in up at the front. What are they trying to show us now? It just seems like they only letting us see certain pieces. They only want us to hear certain pieces. It's just like, I don't know. It's weird right now. What's going on right now?
They got to reset for next week, basically. And what's going on right now is, I guess they trying to get the rest of their little arguments out. You see what I'm saying? But they're going to have to reset it for next week because you can't have 3 rats get on the stand right now. Their lawyer's not present. And you know what? The prosecution are hoes. They're going to bring 3 rats out of the jail who
and no lawyers.
They're going to They're going to try to keep
them in the courtroom.
But you know what they doing, y'all? The reason they doing this, let me tell y'all. Now, listen to me closely, gang. I'm going to tell y'all the reason the prosecution doing this. Listen to me close. I'm finna tell y'all exactly. They crooked as fuck. This is what they doing. They brought 3 rats with no attorneys, so the judge will have to reset everything for next week. And in that time, y'all, they gonna go through Young Thug phones his laptops, whatever they took, they gonna say, get whatever you can, because we got to give him his shit back. They can't give it back now because the judge ain't ruled it. He gonna rule next week to get that nigga his shit back.
That they illegally took.
That's why they gonna go through his shit.
Got you. And that's the thing, like, y'all on some bullshit. You don't bring no motherfucker in here without they damn attorney. Y'all trying to force some shit.
Nah,
like you
they
said,
did that on
trying
purpose.
to forget some. They trying to use them
Look,
they can testify about what they know, and then to stop. Oh well, they don't have any lawyers on their behalf, so we gonna continue this the next week.
And also, it's to make Young Thug scared too. See, when he see the niggas come out there, you know what I mean?
Because now Young Thugger got to see the 3 niggas that's fucking
who's ratting on him.
Exactly.
And now he gonna be in there scared, like, damn, these 3 niggas, damn, they still got my phones. Damn, boy. These
you probably say I don't want to go to trial.
But okay, so don't the evidence that they get out of there, even if they try to hold it till next week, even if it's the stuff that they took illegally, don't that mean they can't use that?
But what they gonna do is this: they gonna grab the evidence out of his phone. They're not gonna be able to use that. Then they're gonna find Young Thug in a situation where they charge him again for something. They're gonna already know what they're looking for because they was in his phone. And when they know what they're looking for this next time, they're gonna already have a warrant ready for what they're looking for. You see what I'm saying? See, what they did was they stole his phones because they didn't know what they was looking for. All right. When they found what they was looking for in his phones, then they tried to backtrack. The judge said, fuck that shit. You didn't have a warrant. So now that they know what they're looking for, they're going to charge him again once they lose.
Once they go straight to it.
And now they know what they're looking for because they already been through his phones. That's
actuality.
Go ahead.
But look, in actuality, these motherfuckers so crooked. They held this phone because when they initially took it to the spot to get them to go in it, they couldn't get in it. But later on, they came up with a technology to get in it. They held the fucking phone.
That's what I'm saying. And they weren't supposed to hold it because remember when they suppressed the weed remember the other judge suppressed the weed? Look, when the other judge suppressed the weed, you're supposed to look at it as a tree that if one apple is rotten on that tree, every apple on that tree is rotten. That's what you say in the political term, the judicial terms. I learned this in college too.
So what that means is what evidence you get. So whatever you get, if you get one thing out of it,
and they throw that out, you got to throw out everything. That's the phone too. But they kept the phone. They broke in it eventually, and now that they got out his information, once he beat this, they can come after him again because now they know what they're looking for because they got his phone. They didn't know what they were looking for at first. Trust me on this, gang.
Well, not necessarily, because if the phone get thrown out, everything, I don't give a fuck if somebody got died in that phone.
I'm trying to tell you that everything will get thrown out, but they can still come after him because now they know what they're looking for. Let me give you an example. Like, I didn't know you owned the red car. I got your phone. Now I know you own the red car. I'm gonna find this red car that you own.
And they use it in a different time. Catch it like and catch it in a different time when you use that.
See, watch this. I didn't know you owned the red car. Now that I stole your phones and I know you own the red car just by going through your phones, now when I come after you, I'm gonna go after that red car. I'm gonna have a warrant and I'm gonna time. Yes, bro, they finna go after his ass because they got the phone. So fuck if they suppress everything in the phone, they gonna have fresh charges.
Okay. So no, he will not be here on Monday. He's currently probably in process into GDC, and once he's processed in, I'll get notification, and then I can start the process, bring him back to court. So it may be one day next week or possibly before trial.
Yes, sir. So we'll go ahead and do the same. The kids come on Monday. Mr. Chamberlain is trying to work that issue with we got to go through GEC and obviously the assess and everything else. So we're going to see if there's any parts of that state.
No, we completely understand all the logistics. We're not trying to rush anything.
Oh, yeah.
We'll deal with it when you get here.
Okay. Thank you, sir. Appreciate
Thank you,
it.
Your Honor.
Yeah, we have business, and if you want to stick around, it's fine. If you want to be excused, that's okay too.
I'll stick around for a minute. Thank you, Your Honor.
Okay.
dude in the comment, he said something that's real slick.
Let that man go.
Dude in the comment said now that all the snitches know that Doug might could get off, they might not eat.
I think this is the first time it even looks like.
Okay, Mr. Menez, didn't we rule on some of your motions already?
Menez, yes, Judge.
Yeah.
We had, no, Your Honor, we only had addressed bond. And then I did have another motion about bond as well, but I had filed about, it was like 21 motions, and I think only 18 of them are required.
Don't worry about it, Caldwell. We can ready to shit up on the
Yes, you have.
So that's one of the guys who's testifying?
No, I think that's Youngthug. I think that's.
Why are we looking at them?
Mr. Weinstein.
Yes, Your Honor.
Oh, okay, right on, Mike. And the real monks. Okay, thank y'all.
All right, we don't have anything else to hear from you for the time being. We're on the table, you know, we're going to table your motion, correct?
That's correct. We also have a motion regarding the rap lyrics, but obviously that'll wait till
the
whatever date that is.
So you're welcome to stay, you're welcome to Mr. Kenner still with you?
He is.
Oh, yeah. So you're welcome to either stay or to proceed on Monday.
Thank you, Your Honor.
I am reading the comment.
Madam, you still representing Mr.
Gunner is
Right?
right.
Yes, Judge.
Now, you don't have any motions at this time, but are you going to file some?
Yes, Judge, I will.
Okay. So do you wish to remain, or do you want to your release?
I'm going to remain because I actually joined it, that's what I adopted.
Okay, all right. Okay, I just want to make sure. Okay, good.
Thank you.
All right. We'll see you again on the 19th. All right. Okay. All right. Rodriguez Ryan. All right. Ms. D. Williams, sorry now. Sorry. Appreciate you being patient with us. Do you have any other motions at this point in time now?
No, Your Honor, I don't have anything right now.
Okay. Do you and your client wish to remain, or you want to? We'll see you on Monday.
See us on Monday.
All right. Have you had an opportunity to talk with the state?
No, Your Honor.
Would you like to do so?
But see, also.
Okay. All right. Just want to make sure. Change your mind. Let us know. Okay. But we'll see you on Monday. Okay. All right. So, Mr. Ryan, we'll see you on Monday. Okay. All right. Thank you, sir.
Because if he do give them,
Mr. Ryan, we'll
if
see
you
you
do
on Monday.
let them have that actual motion to suppress, all of them get checked anyway.
Because that's what they using to hold on you, right? What they found out.
She has emotions right now. She's going to table it for a time being. Ms. Gladden, are you going to be able to join us on
All right,
Monday?
and good night.
Yes, Your Honor.
Okay, all right. Thank you.
Thank you, Judge.
Okay, all right.
Damn bad company, you lost.
Okay, Mr. Sharp, Mr. Botts, we're going to see you all on Monday. I know we're going to.
Yes.
Okay, all right. So, but I'm continuing, or otherwise pursuant to your request, your motion to dismiss and motion to suppress.
Okay.
Is that correct?
Yes.
Okay. All right. Okay.
Okay, on Mr. Jackson.
Mr. Yes, Mr. Jackson. Do you have anything else from Mr. Jackson that you want?
Yeah, we do. I don't know exactly what you're asking me. We do have pending motions.
Such as? I thought we.
Well, dude don't know what's going on. Confused like a bitch.
He looks scared as shit.
He confused. He like, what the fuck is going on?
Now look at his hair. His hair don't look shit like Thugger's. His hair look like a nigga did his shit.
Y'all crazy.
Now look at Thugger's hair. Thugger's hair is to the beat. Look at dude hair.
Shout out to Christian. Appreciate that donation, Christian in the house. Appreciate Jazz. Appreciate everybody.
I'm so sick of this skinny motherfucking bitch right here. I don't know what to do.
Man,
the bitch with the bun.
Yes, I'm sick of her, man.
They in here, man. They in the house, man. This nigga done took 3 shits and now he done reset it for Monday. Going down, man. It's going down. This is a good trial, y'all. This is what I'm gonna do, y'all. All right. While I'm in Austin, I guess I'll pull some paperwork on Thugger, Young Thug, and Ghana. Send me whatever y'all got on this. Since we watching this case, we might as well pull the paperwork to see what the fuck we watching.
Man, I keep trying to tell people. I'm sorry, I didn't mean to cut you off, brother.
Oh, no, you good. But
Close your trial?
Absolutely.
Or before that particular evidence is supposed to be admissible?
Yes, Your Honor, and I'd imagine I'm not the only party that's going to be interested in that.
Okay.
We filed a motion in limine that kind of complements that motion. We kind of said, okay, so we responded out to this. We also have the state's motion in limine to admit co-conspirator hearsay, which is related to that motion, so we'd be asked that they be heard at the same time.
Okay. All right. So I'll table that for the time being. What about the motion to dismiss the indictment, motion to amended motion to dismiss?
I have it, those are on constitutional speedy trial grounds. It's going to be a bit lengthy, in all candor to the court, but I'm at the court's pleasure. I will also inform the court that I do need to speak with the state because there are specific photo lineups that were presented to a witness that I'm unable to find in the discovery, and I'm not attributing blame to the state, but I need to figure out where those are because that's going to be an issue regarding a witness as well.
Your Honor, I'd ask that the court allow us an opportunity to speak a little bit further to flesh out those issues with Mr. Sharp and to have his a motion to dismiss based on constitutional speedy grounds heard at a date later than today.
Okay. All right. Okay, that's fine.
I'll send you that was some crooked ass prosecutors, man. That motherfucker's crooked as shit.
He want his shit to suppress. That's
Mr.
why he
Hoover?
want a dismissal.
Cause he's seen
As it
with
pertains to
Young
Mr.
Thug.
Summer, didn't we take care of your motions already?
Most of them, Your Honor.
Yeah, which one's left?
Well, the majority of them have to do with, after we get done with the 702 hearing, so that's not an issue right now.
I can't get over
The
his
state
hair. His
is
shit
trying to use
fucked
two of my
up.
clients' priors against them, so we will have to take that issue up at some point. And other than that, I just have a motion in limine that we can talk about once we get close to the trial.
Okay, all right, so you're covered, all right, just want to make sure.
Yes, sir.
Okay, all right. Where's Mr. Rubin?
He's not here, Your Honor.
Obviously. Oh, when he leave, where's,
I think he's in the email to Mr. Kern in the court.
He said,
Mr. Kernan, do we know anything about Mr.? Okay, all right, I understand. Okay, I just wanted to counsel him. All right, no problem. Okay.
On behalf of Mr. Sumlin, I would like to state, but Mr. Sumlin has expressed that he does not want to, and I'm okay with him not being here for it.
Oh, you gonna waive his presence?
Yes, Your Honor.
Mr. Sumlin, you okay with your lawyer just being here for purposes of any other things that might be of interest to you?
Yes, sir.
I'm sorry?
I said, yes, sir. I don't have to use it.
Oh, fine. Okay, yeah. Do you want to come back after you use the restroom or what?
Yes, sir. Yes, sir. I just had it.
Okay.
Yeah, I won't come back.
That's fine. I'll let him wait his presence for the time
Locked
being.
up too. I want to see that bitch
How
all
the
day.
fuck this nigga so friendly?
Because he know they ain't got no case.
You wanna come back? You wanna go use the bathroom? You can do what you wanna do. You wanna go get something to drink? Fucking ass.
All right, Evelyn. I think we're good.
The text is that everybody gotta take a shit today.
Let me take up. I don't think there's anybody else that can take up. There's one more seats now. Witnessing it.
They need to stop moving around. I'm trying to hear what they're talking about.
Yes, Mr. Harvey.
Would like to also be excused at this particular point. This is back starting like mine.
All right, sir. I have, assuming that you were waiving his presence, that's fine. I don't think I'm going to go much longer. I'm going to I think I have to take up with one witness from the state. Is that right? And I think that's it I think that's going to be it for today. We got a little bit of a late start due to technology. It wasn't anybody's fault, but just so just so we can kind of move accordingly, that's what I was gonna do. So, Mr. Menez, I'm gonna hold off on, are you having discussions with the state, sir?
See, he wants them to come up with a, he
Mr.
don't want
Menez?
them to go to trial. That's why he keep asking.
Are you having any, I'm gonna hold off on your motions because I've kind of run out of time and space for today. But, are you having any discussions with the state, sir?
Not any more than a regular police judge.
No, we ain't talking about nothing.
So now it's cool. I'm ready to go to the crib.
Nah, we ain't trying to cut no plea.
Ms. Love, or Ms. Hilton, have you had any discussions with Mr. Menez?
Your Honor, we had a conversation with Mr. Menez last night. At this point, we are still in conversation, and he would like to have a conversation.
Okay.
And just to be around the conversation about a plea that doesn't involve any type of collaboration.
Well, I don't need to know anything about that. And that's up to you and your client, and certainly, I don't want to violate any attorney-client privilege, but that's certainly up to you, sir. And whatever you can negotiate with the state, if that's the case, I'll let you all finish those discussions, okay?
Because if you don't take a plea, the shit get dismissed.
Okay, all right.
He's helping.
Do you wish to waive your client's presence?
No, Your Honor, he's in the state.
Okay, all right. All right, State, go ahead and call your witness, so we can go ahead and take this.
Thank you, Your Honor. We're going to call Agent Raisi to the stand.
Agent who?
Raisi, R-A-I-S-S-I.
You okay, Christina? Do you need that?
People keep trying to say, is young is gonna a snitch? Of course.
I don't know. I don't think he did.
Yes, I'm sorry. He's a rat. Let me tell you something. In these
Not,
type of
just wait. I ain't gonna be able to hear you. I really
Okay,
want to hear what
I
you
got
gotta say. Say
I
that.
got you.
What they doing? Getting set up to go home?
Are you Agent Rahisi, sir?
I am, Your Honor.
All right, good afternoon, good evening, sir. If you could please approach the witness stand once you get there, if you'd be so kind to turn and face Deputy Talton, sworn as a witness, please.
You ready to write? You swear the firm testimony to the court, the whole truth, nothing but the truth.
I do.
You take a seat. State the story, first one.
It's David, D-A-V-I-D, last name
Nah,
Raisi,
don't start fucking up
R-A-I-S-S-I.
now.
Go with the bullshit.
Good evening, Agent Raisi. Where are you currently employed?
The Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly referred to as the ATF.
And how long have you been with the ATF?
About 2 years.
Prior to working with the ATF, where were you employed?
The Cobb County Police Department, Georgia.
I'm sorry.
Just was making it clear, Georgia.
And how long were you with the Cobb County Police Department?
12 and a half years.
What was your last assignment with the Cobb County Police Department?
I was assigned as a detective to the Crimes Against Persons Division and also a task force officer with the ATF.
And how long did you serve as a detective within the agency?
6.5 years.
I want to take you to July 2015, where you worked with the Cobb County Police Department.
I was
And what capacity was you working with the Cobb County Police Department?
a detective in the Crimes Against Persons Division.
And during this period of time, did you have the occasion to conduct an interview with Jeffrey Williams?
I did.
And where did you conduct that interview?
I was at the Cobb County Jail on Memorial Drive.
And do you see Mr. Jeffrey Williams in the courtroom today?
I do.
And if you can identify him by article closing that he's
He's sitting to my right at the defense table, a third gentleman over, wearing looks like a dark colored jacket, white shirt, and a tie. The third subject over.
Your Honor, let the record reflect that Agent Raisi has identified Mr. Williams.
It's yeah.
And why did you want to speak with Mr. Williams in Cobb County Jail?
We had a shooting that occurred in Cobb County, April 26th of the same year, and we believe that Mr. Williams may have some information or be involved in that incident.
Now, you work for Cobb County, but you was in the DeKalb County Jail.
That's correct.
Do you know why he was in the DeKalb County Jail?
He was arrested, reference to a warrant out of DeKalb County.
And when you went to the DeKalb County Jail, did you ever speak to him about his DeKalb County case?
No.
Now, when you went to the interview, were you there with anyone else?
Yes, I was.
Who was you there with?
A special agent with ATF, Tyra Cunningham.
And why was Agent Cunningham with you for this particular interview?
The ATF was involved in a larger investigation, and she was one of the representatives that were there, and I got in contact with her just to see if I could go to DeKalb County and interview Mr. Williams in reference to my case.
Now, when you went to DeKalb County to speak with Mr. Williams, were there any warrants for his arrest as related to the DeKalb County incident you were investigating?
No.
Was he a suspect in that DeKalb County?
No, not an official suspect, just potentially involved person or someone that would have information for us.
And when you went to the DeKalb County Jail, were you able to speak with Mr. Williams?
I was.
And did you read him his Miranda warning before you spoke with or interviewed Mr. Williams?
Special Agent Tyra Cunningham read him his Miranda warnings, but yes, I was present when that occurred.
And why did Agent Cunningham choose to read Mr. Williams his Miranda warning?
Objection. Speculation.
Did you all have
Okay,
any
I'll stand objections to form. Go ahead and rephrase, please, Madam.
Did you and Agent Cunningham have any conversations prior to going in about reading Mr. Williams' Miranda warnings?
Yes.
And what was your reason for wanting to still read Mr. Mr. Williams' Miranda warnings?
He was in custody, and we were going to be questioning him. And we were law enforcement, so.
And again, he was not in custody pursuant to what you were investigating in Cobb County.
That's correct.
Now, when you began interviewing Mr. Williams, did he appear to understand English?
Absolutely.
Did he appear to be under the influence of any drugs or alcohol?
No, he did not.
Did he appear to be coherent?
Yes.
Did he appear to be sick at all?
No.
Did you give him any promise or hope of benefit to get him to speak with you?
No.
Did you coerce Mr. Williams into making any statements with any threats or actions?
No.
Did you hold out the remotest fear or injury to get him to speak with you?
No.
Now, you can tell the court a little about your style and how you interviewed Mr. Williams.
This interview was non-confrontational, more of like a conversation interview. Mostly just about background information. It wasn't directed towards any sort of particular crime until the latter, probably.
So we lost sound again.
There go that bullshit.
Definitely that bullshit. They cut the sound. I believe you now, yo.
Yeah, they cut that sound.
Yeah,
because
It's just way too random.
It sounded like he ready to say that Young Thug told. It sounded like he ready to say Thug got there, give us some information.
It sounded
Yeah,
like
it was a conversation interview. Man, that's some bullshit. If it ain't on black and white, that shit don't exist, bro. Talking about in good faith. Get the fuck out of here.
Man, I'm telling you, it sounded like dude was ready to say, man, he cooperated, man. Dang.
Well, we'll see, huh?
Yeah, we'll see.
But what I was ready to tell you is that the charge that they got, when you catch them type gang charges, when you take a plea, that's ratting. He ain't had to sit there and say somebody did this, did that. By him taking that plea, that's ratting. And then also him saying they was a gang and they commit crimes, that's ratting. He ratted.
Already.
It don't take a rocket scientist to figure that out.
Yeah, that's what they call dry snitching.
That wasn't even dry.
And that wasn't even dry. It was wet. Oh, God, man. That
That
shit was wet as
wet.
shit. Motherfucker was dripping, saucy. You hear me?
I'm telling you.
And then
You know,
for them to block out this part of this witness testimony is some
it's crazy.
bullshit.
Yes, definitely. Some bull. But yeah, him saying that. Because now they don't have to prove it if they're a gang. Him saying he's like the second in command. Your second in command said y'all a gang. So no, ain't no YSL that I'm labeled. It's YSL the gang. And y'all commit crimes. Oh wow. Okay. Crazy. Anybody you see saying he ain't told, they telling. Ain't a whole lot to that. That's crazy, man. No people, this whole testimony, they're ready to stop this whole testimony right here.
He's oh gosh, in so many words, they say this for the end, knowing good and damn well what he was getting ready to get up here and talk about.
Mm-hmm. And then the shoot he talking about, that's the shoot between Thug and the other dude. Young Thug ain't look so good in the face
now
right
we
there.
black. Now we black.
Young Thug ain't look so good in the face right there.
I'm going to first show you what's been marked as States Exhibit 5 NJW. Tell me if you recognize States Exhibit 5 NJW.
I do.
And how do you recognize States Exhibit 5 NJW?
This is a advice of rights and waiver form, commonly referred to as a Miranda form, that the U.S. Department of Justice, the ATF, utilized, and it's what we utilized on the day in question.
And is that the form that you went over with him?
That, yes, we did, jointly, yes.
Is this a fair, accurate copy or depiction of the form that you went over with Mr. Williams back in July 2015?
Absolutely.
Your Honor, this time to say like the Tender States Exhibit 5 NJW into evidence.
Any objection, sir?
Not for purposes of today's hearing, Your Honor.
Okay.
Same for the next one.
All right, States 5 MJW is admitted for purpose of the motion.
Okay, and I'm also going to show you what's been marked as States Exhibit 4 MJW. Do you recognize States Exhibit 4 MJW?
I do.
And how do you recognize States Exhibit 4 MJW?
I reviewed and listened to the audio on this disc this morning, and I initialed and dated the disc.
And that appears to be the full interview that you had with Mr. Williams back in July 2015.
Yes, there are 2 files, full interview.
Okay, Your Honor, this time the state will also like to Tender States Exhibit 4 NJW into evidence.
All right, no objection?
Right, for the purpose of
the motion. So States 4 MJW is also purpose of the motion.
Thank you, Your Honor. Now, Agent Rice, if you can go through from beginning to end the states of rights form that you did or completed with Mr. Williams back in July 2015.
Yes, ma'am. You want me to read that top to the bottom of every word?
Top to the bottom.
Okay. U.S. Department of Justice, Bureau of Alcohol, Tobacco, Firearms, and Explosives, Advice of Rights and Waiver, and it's titled Statement of Rights. The first bullet point is you have the right to remain silent. Second bullet point is anything you say can be used against you in court. The third, you have the right to talk to a lawyer before we ask you any questions and to have a lawyer with you during questioning. Fourth, if you cannot afford a lawyer, one will be appointed for you if you wish before any questioning begins. And the fifth bullet is if you decide to answer any questions now without a lawyer present, you have the right to stop answering at any time. Next is a waiver. It says, I have read this statement of my rights or have been read to me, and I understand these rights. At this time, I am willing to answer questions without a lawyer present. No promise or threats have been made to me, and no pressure or force of any kind has been used against me. Then there's a signature line, a printed name line, a witness signature line, a printed name line, a date and a time, and then a note at the bottom margin, note previous editions are obsolete, and then the ATF form number 3200.4, and it was revised September 2005.
And that is the form that you went over with Mr. Williams back on July 15, 2015.
Yes, ma'am.
Was Mr. Williams ever arrested as it relates to the Cobb County shooting you were investigating?
He was not arrested.
Did you ultimately arrest someone as it relates to that case?
Yes, we did.
And who was that person that you were arrested and charged in that incident?
Jimmy Winfrey.
Your Honor, this time the state would like to, they can do it now or they can do it later, publish State's Exhibit 4 MJW, the relevant portion, Your Honor.
How long are we talking about in terms of,
Probably the relevant portions, at least for this witness, would probably be about 7 minutes.
okay. All right.
It is obvious.
All right, go ahead, get it, go ahead and play it.
Come on, girl, play this shit.
Yeah, this is total. Well, the total, Mr. Steele's correct. The actual portion is about 10 minutes and 45 seconds. Is that okay, Your Honor?
Okay.
I made no statements
Your
other
Honor,
than
or if anyone would add.
Hold on.
okay.
We
Hold
can
on.
share share capabilities for
I don't know if I can do that right here.
You want to read it real quick?
West, you have the ability to do
You got time.
I know there's a CTS on the screen going to send us.
Who? Can we get those of you who may be on the Zoom call from IT, can I get you to please authorize screen sharing for our district attorney, please?
I thought he was on. Oh shit. Okay, it says, I want to make it perfectly clear that I have not made any statements, have not been interviewed, have not cooperated, have not agreed to testify or be a witness for or against any party in the case, and have absolutely no intention on being involved in the trial process in any way. Gunna releases a statement clarifying, and I know the bottom said. Man, do her, bruh. They fucking up. So for everybody calling Gunna a rat and this, that, and the third, watch your lips. Man, so y'all saying his hair look good. Y'all telling me they did him right. Okay.
Somebody say he pleaded guilty and it's told at the same time. Somebody say he forgot to say yeah after everything.
I swear it sound like people be wanting motherfuckers to be a rat. Yeah, when the first thing a motherfucker want to say is, I told you he a rat. If he ain't ratting, he ain't told, let the man, hold his,
Okay,
his,
go ahead.
He
his respect at this point.
He definitely a rat. Just because he said
Prove
it.
it. Prove it.
I just proved it to you. They're in
You
a
ain't proved shit to
RICO
me.
case. They're in a RICO case. He took a plea in a RICO case. That's ratting. You could ask anybody who ever been in these cases.
But what is that? I thought that just meant that he plead and he admitted to his doing and what he didn't do. And
Yeah, while everybody else is going to trial and saying they didn't do anything.
But he didn't do shit. He been saying he didn't do nothing from the very beginning. He been
Everybody's
begging to get
saying
out.
they didn't do anything.
Not like him. And they
Everyone
even
is saying they didn't do anything.
No, and they Man,
You
no.
tripping. He
No, they
said,
wasn't.
we a
He ain't know
gang
no music.
and we commit crimes. He said, we a gang and we commit crimes. And these people is going to trial for being a gang and committing crimes. Do I got to spell it out?
I guess.
SNITCH. Shit, nigga, I'm coming home.
No way you are wrong, sir.
Shit,
But
nigga, I'm
listen,
coming home.
I'm gonna let you have your pee, but you wrong.
He said, shit, nigga, I'm coming home.
And the paperwork will soon be out, and you make sure you hear Mr. Rebel.
You don't need, listen,
Because,
you don't need
saying a gang, you can say you a gang and commit crimes, and it don't got to be murder.
Not when your gang is going to trial. Are you crazy?
He didn't say what crime.
Listen to yourself.
A crime is a crime is running a stop sign. Prove
wow.
it.
Okay.
Prove I ran that stop sign. Prove it. I can say whatever. Hey, my name is Candace, and I'm filthy rich. What? Prove it.
But if me and you in the car, in the same car, and we fighting the same case, and I take a plea and say, yeah, we was running stop signs.
Like you said, you can plead.
We came together.
What if you plead the fifth? That's a plea.
They don't plead. That's ratting.
No. A rat is if you agree and you're in the middle of doing something and you tell. If you just are guilty by affiliation, then you just told.
He agreed with the state. That's ratting.
We can go back and forth all day.
Anybody was
just that's telling. That's not ratting. That's telling.
I guess because ain't nobody. He ain't say he told, right? So that means he ain't tell.
No, I'm going by what I know.
So if you got common sense, what I just said made perfectly sense.
Fuck you and your common sense. Don't tell me about no common sense.
So now I understand.
Your common sense.
You're right, sweetie. You're right.
Your common sense is because he said he was in a gang and he committed a crime. Everything that they did, he's admitted.
It don't matter what I say. You already made your mind up.
You're right. You're right. Just like you have. And look, he's smiling. First time I done seen Thug smile the whole time. Something went good. Something went good for my nigga. Now, dude over there with his hair all fucked up, I don't know. He don't seem too positive. Motherfucker said you can't read. You ain't got common sense. He had to take that plea. Don't. KO said, don't go back and forth with her. She thinks she knows it all. If you ain't lived this, you don't know about it. How the fuck you know what I didn't live, nigga? You don't know me. Shut your ass up. You don't know me. You don't know what I live, nigga. Now do that. Now ride that, KL. Nigga, because I'm a girl. So have I. So shut up. You got a lot to say about rat. You must be a rat. Nope. No, your girl accountability means you rat. Listen, now, if he starts telling them people, then that's a different situation. Then I will, but I just can't go off of that. That's all I'm saying.
People in the comments is crazy.
They nuts. Well, he's still a rat. Actually, I read this 10 times over so I can say all that plea deal is not facts. Sis, you don't even know what a rat is. You can't even spell rat, so shut up. Y'all tough Tonys in no comments. Come up on the platform, tough guy. Let me get the cheese out for you.
For sure.
Come here, Jerry. Bring your little ugly ass up here. I'm about sick of you. Shut up. I can't lie to you. Somebody said it's someone getting their haircut. It do sound like it. Lord, y'all so crazy. Oh, I ain't even my feelings on that. I mean, that's my feelings. It do like sometimes come vibrate. Y'all could try my girl now. Y'all hate. Yeah, they mad. It's okay. Because I don't agree with what he said or what they said. Watch how you handle my feelings. Okay, Aquarius Nation already. They took a break in the middle of the state. Oh, I thought she was talking to me. My fault. Jerry the White. I hope that's not your last name. That first name. He took a plea to keep him from testifying because if Doug goes to trial, he has to take. Oh baby, you rat on me. Made a deal and went home today. Lay it down, girl. Just got in. Where's paper? He's taking a break. We've been going for 5 hours and 61. Let's try. This has been a long trial. Well, I circulate the paperwork for telling him how to tip. Exactly. Damn mute. Damn mute, Argentina. Y'all crazy.
I was trying to read slow.
What did you just say?
Yeah. I was like, let me go slow so I don't just.
Right, so that you know, we're trying to see if we can get a Bluetooth speaker. Yes, because we can't push the system so the microphone.
Yeah, let's put the microphone and let's see if we can kind of make that work. We've done that before.
Yo, what's that? Shut up, little girl.
All right, so y'all know the prosecution is playing that what's name right now. They playing that 10-minute tape. She just asked the judge, and she played a 10-minute tape. Now they don't want us to hear shit. They doing everything. So that's what she's doing, y'all. She playing a 10-minute tape. Yeah, so that's what they doing right now. Yeah, this is a long ass trial. Somebody just said that in the crowd. Yeah, this shit long, y'all. We went 3 this morning. Then I had to go somewhere, came back and jumped in and did it. Now we on 5. That's 8 hours on this shit, man. But it's going down. At least we together. God damn. $8 on this shit, and the prosecution ain't got no evidence. No, they just sitting up here just dragging it to the judge.
Facts.
They
They
didn't
get
have no warrant.
tired.
Yeah. Be like, oh, I forgot, y'all didn't have no warrant.
Oh, yeah, they trying to confusing paperwork. They trying to make it legit.
I'm glad that it's on TV because a lot of people need to see this. A lot of people don't
we're
think
back.
it's going
I think it's working.
Oh shit, wasn't working.
That's fine.
That's right. That's right. Exactly.
It should. Tell us some stuff about it. I don't have a
It's crazy how many people don't understand shit. Sometimes they take rocket science.
Excuse me, if you want to share your screen, you need to mute your laptop's microphone and your laptop speaker. You won't need that.
the team is here. Your laptop speaker. I'm sorry, y'all.
Is it working, Miss Hill?
Thank you.
Y'all in these comments are having it out. Y'all might as well just put that out there. I know what they want. I'll go back to now they can't even get the 10-minute audio on the play. You mute your laptop speaker, please. Mute your laptop speaker. Dwight, I know you want my attention, okay? You got it, little boy. Hello, how are y'all doing tonight? Happy to be here. Hey, Tasha. Damn, they got Andy Griffith celebrating. Who are Jerry Dwight? Who are you? Look, everybody look restless. Look at the judge. The witness turn. Don't. It's not. I love you, baby. I do that. I always.
Is this Simon Hilton?
Ms. Houghton,
I love to play that.
Adrian, do you want to talk to this?
She's coming back.
What do you need us to do?
Hello, yes, so my name is Abade, I'm from Core Technology. I would like you to please reshare your screen so that the sound can come out properly. Please stop share. Hello, can you follow my direction?
It take them this long to set up that.
I am the technical editor.
You need us to stop the share.
Yeah, for a quick yes.
All right. Okay.
Good. So next time you click on the share screen button, please, there are two checkboxes underneath the window. One of them says share sound.
They were checked, and we will check them again, like.
You were checked?
They were checked.
They didn't rehearse this or they didn't practice before they got home.
Now, we can take out and optimize for video clips, if that's not.
You can leave them. You can leave them. That doesn't matter.
If you much don't trust you, I'm gonna shoot you.
I'm gonna tell you what, that if you say that what the other say it ain't ready, you probably hang around.
You already know I'm going happy. Y'all hear me? It has been because they have some technical difficulties. Shut your lips. It was working for we're going to the chapel. Beautiful
all the different shit they do. Little different tactics also. I just heard that judge say he tried to get out of there. You the hell that man up another 15, 20 minutes.
You are not supposed to talk to people. I didn't think
Your Honor, I think we can work with Agent Rice's schedule in order to finish the rest of the motion.
Okay, all right. Mr. Steele, it's okay with you. We have some other administrative concerns about the personnel that we've been involved in today. And it's at 7 o'clock. As much as I'd like to be ooh-ah and
tell me what to do.
Discretion might be the better part of just putting a pin in for today and us picking up for this at that time.
Understood.
Okay, all right. So, Agent Reese, the state will go ahead and arrange for you to come back on a particular date and time, and we'll take up your testimony at that point in time.
Yes, sir.
Okay? All right, thank you, sir. Don't discuss your testimony with anybody except the attorney in this case, okay?
Yes, sir.
All right, thank you, sir. All right, let me go ahead and, for the purpose of the record, just put on the conversation I had with Mr. Steele.
Hey, some hoe ass niggas gonna cut the comment. We've been waiting to hear what conversation he just had. They gonna cut that bitch.
And they gonna find it. They gonna cut it after we waited and was begging.
And then you see that black bitch running around. That's the DA that's trying to prosecute. That bitch ain't got no goddamn case. So now I know she ain't got no case. Well, they probably got something, but they ain't got what they need.
How y'all been investigating 10 years, man, and ain't have a search warrant?
Nah, trust me, they sloppy as fuck. But they rushed in to go do something on this man, and it didn't have no proper cause or nothing. I'm hungry as fuck, gang. You see what I'm saying? Wait, because I know as soon as we cut this bitch off, they're gonna say something. See, the judge saying something right now we need to be hearing, but they keep cutting the shit off.
We gonna fuck around and miss it. Somebody else gonna have that shit on their shit. They gonna post like we were here live. They gonna post the shit like we don't know what the fuck going on.
Look like ain't nobody gonna get to hear this shit the way they keep cutting the shit out. They let us out of those.
Especially after we done waited 10 hours. We didn't get a whole shift. We didn't get a 12-hour shift damn near.
But I'm gonna tell you, he straight carried them if on that motion, man, or that motion to suppress, unless he's doing all that next week.
Nah, you right. You 100% right. He actually helped the prosecution out a little bit on that. He's giving them to drag this shit along and this and that. This nigga know for a fact that the motherfuckers is don't got no fucking case. And that's one thing I hate about when they bring a case that they don't have no case. They always try to convince the judge that, look, I do have a case. Like, come on, bro. I don't give a fuck how many people snitch on Gunna. On my bet on Thugger. Either way it go, that's after the fact. Y'all didn't have no warrant. I mean, it all boils back down to the warrant, but they don't know that. I think the judge gonna do some fuck shit though. It look like he gonna do some sneak shit, y'all. For real. Monday, we're not gonna forget the fact that they didn't have a warrant. Matter of fact, Monday, that's gonna be one of the main things I'm gonna talk about is they didn't have a warrant. We're not gonna forget. They want us to forget, but these snitches gonna be beautiful. I want to see who the fuck finna get up here and snitch. That shit finna be beautiful.
Which it shouldn't even
Why you
get
say
that
10
far.
hours?
It shouldn't even get that far, man.
Boy,
The thing about it is, I don't feel
time to
like
go
they
live at
prepared
7 at night. Yeah, we did the morning show, went all the way to this motherfucker. But nah, I got
tonight.
to finish.
But then it don't look like they was prepared though, paperwork. You feel me? Like you said, they ran in too soon. They just don't seem prepared. This is some bullshit.
Nah,
And I feel like
they,
by them not having it together, he
this is
should
something
be
they
at
always
least
do.
free.
They always fuck with you, steal your shit, and then go try to get a warrant to go to your shit afterwards. They do that shit all the time.
And in actuality, he's been all over the place these last 10 years. You know how many times they had to close that case and redo some shit? People made all types of mistakes.
Most definitely. Oh shit. They gonna think I'm here trying to snatch views 5 fucking hours.
You doing like they do. Motherfuckers going forever. You hear me?
But
I'm a regular.
On Court TV paperwork, it's not gonna be this long, guy. On Court TV paperwork, we're gonna get right to the point. It's gonna be those trials that are just like 30, 40 minutes, family court trials and that. The only time we'll go through a big trial like this long is when it's somebody like Thug or R. Kelly or someone. Then we'll sit down and watch this shit because it's well needed to see these celebrities. But as far as regular trials, nah, we're gonna be here an hour, 2 hours, 30 minutes.
But see, regular trials probably would be different. You know, regular trials might be a little spicy. They might be a little bit more like cutthroat. Like they doing long-winded shit right here.
This ain't even a trial. It's a hearing. It ain't even.
Yeah, it's a hearing.
It's a hearing.
It's the hearing of a trial. It ain't even a fucking trial. Goddamn.
Long ass hearing.
It would have actually been trial, but he filed that motion to suppress before the trial. So
y'all hear him keep yawning. Them is them tired, them sleepy yawns too. It ain't like that.
Get up. Everybody else, y'all look at them. They over there asleep. He got to wake everybody up.
I told you the judge on his head. Look at her. Look at her over there. She
knows she just woke up. They finna cut the volume back on. Bitch, we don't want to hear it now. We wanted to hear it with the judge. We don't want. They would think we want
shit.
Come on now, Marquesha. I knew it was coming. I told you. I knew it.
All right, gang. Look like they may be coming back. Who knows? But I'm about to get the fuck up out of here.
That's what they normally do. You haven't heard. You sleep. You gonna tuck in.
Nah, I got shit to do. I'm finna hit the town. I'm in Austin, man. I gotta hit the town real quick.
Austin, that's right.
It's still early out there, right?
Huh?
It's still early out in Austin, right?
Yeah, what is it? 6 o'clock. Well, shit, 6 o'clock. Goddamn.
6. I thought so. They are hour behind me. It's 7:05 where I'm at.
Yeah.
It's still early though.
It's 7:05 where I'm at too.
All right, check it out, gang. We're gonna bore y'all long. We think this trial is over. The court date has been reset for Monday, December 19, 2022. Be sure to tune in tomorrow morning for Court TV with Paperwork Party. All right. Be sure to tune in tomorrow morning for Court TV with Paperwork Party.
Gang,
all right,
gang.
We're gonna have it tomorrow morning. And remember, on Saturdays it's noon time. You see what I'm saying? Same shit, different toilet. Get to the clubhouse, gang. All right, the clubhouse.
Yeah. Your moderator get to the clubhouse.
It's already pinned to the top. I love y'all so much. I'm about to go get me a steak. All right, I'm about to go get me a steak, and I'm about to go get drunk real quick. It ain't gonna take me long.
Ooh, stop eating that steak. You ain't gonna be able to take a shit no more. You're gonna be fucked up.
Gonna still a rat.
No, we're gonna find out. Watch this. We're gonna pull that paper.
We gonna have that paperwork.
We're gonna pull that paperwork. We're gonna see what's
and I want a honey bun from you, Rebel. If that shit happen, I want a honey bun. And on my Cash App will be in your back channel, nigga.
But you notice now, I never said he was a rat.
You did. Oh, hell no. All right,
he's
paperwork.
A rat openly.
Paperwork, take us out. Take us out. He lying now. I put that money on that
All right, we
shit.
and get to the clubhouse. Raise your hand for the moderators. We're about to go in 24-hour clubhouse. I'll see y'all tomorrow morning. If you want to hear from me, hit me in the clubhouse, man. Let's go, gang.
Let's go, gang, gang.
Bless you. What's up, paperwork party? Gang, 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 gang. It's paperwork party. Paperwork gang, gang, gang. Hit the like button. Let's go. When you come in, let go. Hit the like button. Hit the like button. Hit the like button. My likes should match my views. Right, man. Hit the like button. Hit the like button. Hit the like button. My likes. So when you come in, hit the like button. What's up? My likes should match my views. Hit the share button. My likes should match my views. Hit the notification. Let go. Let go. My likes should match my views. Come on, y'all. Yeah. My likes should match my views. Let go. Hit the like button. Hit the like button. Yeah. Hit the like button. My likes should match my views. Hit the like button. I hit the like button. Come on. Hit the like button. My likes should match my views. Let go. Let go. My likes should match my views. Let's go. My likes should match my views. My likes should match my views. Let go. Let go. My likes should match my views. Hit the like button. What's up, paperwork gang? Gang, gang, gang. Yeah. Hit the like button when you come in. Hit the like, notification, man. Notification, man. Cash out, let's go, y'all. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Let go. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Let go. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out, come on, y'all. Or get your ass out. Cash out, man. Yeah. Or get your ass out. Just get out, man. Come on. Or get your ass out. Donate to the channel. Or get your ass out. Hit the cash out. Hit the cash out. Hit the cash out. Or get your ass out. Hit the cash out. Come on, y'all. Hit the cash out. Hit the cash out. Or get your ass out. What's up, paperwork party? It's paperwork party, paperwork gang, gang, gang. Hit the like button when you come in. Let go. Hit the likes or get the hell off my page. Paperwork party. I done stepped up on the stage with no script laid. Come off the fade on this page. Riding with a 12 gauge, I'm spilling the lemonade. My helicopter got blazed, a condominium with base. They ask my real age, I'm chilling within the squade. Hit the like button. Hit the cash out, donate, don't hate. I'm in Mexico sitting on wait. Hit the like button or get the hell up off my page. Paperwork party. I done stepped up on the stage with no script laid. Come off the fade on this page. I'm riding with a 12 gauge. I'm spilling the lemonade. My helicopter got blades, a condominium with maze. They ask my real age. I'm chilling within the square. Hit the like button. Hit the cash out. Donate, don't hate. I'm in Mexico sitting on wait. What's up, paperwork gang?